almost annual event that Brett Olander and I sponsor. We're very proud to have you and grateful that you came. And if the numbers show up today like they have been registered, we really expect to have far in excess of 150 people, maybe 160. So when Brett first came to me and he said, I want to do this CLE, you and I can do it together. It'll be kind of a plaintiff's perspective defense. And I said, oh, yeah. I'm thinking in the first year, what do we have, 30 or some people? And I thought, this is going to die on the vine. And it's done just the opposite. We keep getting more and more folks. And we're committed to a format, though, of only having like 20-minute presentations. So nobody is allowed to go too long. If they do, I usually come and stand right next to them on the stage and stare at them for a while, and then they sit down. But it's the only CLE in town where you get free BS and free booze all in the same day. So throughout the day, we're going to be giving away, we actually have wine and beer and hard liquor that have all been donated, and we'll figure out a way to do that. The other request I would make is please stop by the booths of our sponsors. These folks come here for nothing and oftentimes donate things or pay a fee to present to you. So please stop by their booths. Please try and use their services. They're wonderful people, and many of them have been coming back to us for years. Our first speaker, if I can read it, is Jerry at the Capitol. They're going to give us kind of a rundown on public and political issues. And as you know, with the midterms and everything else, there's, I think, a lot to be said. Joel Carlson has been a friend of mine for 40 years, and I was at one time, believe it or not, president of the Trial Lawyers Association, and I worked very closely with Joel, and both Jeremy and Joel are considered the best of the best at the Capitol. So Jeremy and Joel.
Well, thank you again, Mr. Carey, for that. I'm Joel Carlson. I own a legal research and government affairs business here in St. Paul, and I apologize to all the MAJ members in the room. You've probably heard some of what I'm going to say 4 or 5 times already since session ended, but we're going to get we'll get through that. And I have known Jim Carey a long time, and despite that, we continue to be very good friends. I've represented the Association for Justice, or it's hard to wring out the trial lawyer out of the title, but since 1994 at the Capitol. I've been their chief lobbyist for a long time. But I also represent the court reporters. I represent another group of lawyers at the Capitol, and so a lot of what I do at the Capitol involves and touches the work that you do. And I've appreciated being invited to speak at this seminar because of the collegiality that you bring to it. And quite frankly, we are in a hyper-partisan and sometimes non-productive atmosphere at the Capitol right now. And the way this group cooperates and can work together to resolve legitimate legal disputes that you have, I think is in short supply at the Capitol, and please feel free to come over anytime and give them some advice. So I'm going to note a few items of interest that passed or received some attention in the 2022 legislative session. I'll briefly touch on the 2023 session that is going to start on January 3rd of 2023. And then I'll mention just a couple of points about the upcoming election. Then Jeremy's going to take it over from there and do a deeper dive into the election, and we hope to leave a little bit of time for questions at the end. So the 2022 legislative session began on January 31st. They had high hopes for success. They had $1 billion surplus They were going to run in new legislatively redrawn districts because of reapportionment. Everyone wanted to cooperate. They had such high hopes. They were going to have tax relief. They were going to do a huge bonding bill of $1.6 billion, which benefits everybody running for reelection. Unfortunately, whether it's Lucy pulling the football away or the legislature again showing its ability to snatch defeat from the jaws of victory, none of that happened. They couldn't reach an agreement on a tax bill that included many popular positions, including eliminating the tax on Social Security benefits, and I see that's going to impact some of us at some point here soon. They couldn't agree on a bonding bill, a capital investments bill that were, $400 million of local projects that you all get to go to a ribbon cutting for in your districts, investments in roads and bridges and college campuses. They couldn't come to an agreement to pass a bonding bill. They had agreed to the overall scope of spending for a human services bill for long-term care, and I don't know if you've been watching in the news, but that industry is struggling with both staffing and funding issues. They had committed $1 billion, an agreement to commit $1 billion to human services, $1 billion to education, $450 million to public safety, a little over $60 million to increase funding to the judiciary. None of that happened. It all crashed in the last week of session. And so on the major issues of the session, which they had high hopes for going into the session, they kind of scored a 0. And that's unfortunate, I believe. They'll go into the 2023 session with about a $12 billion budget surplus. If trends continue, revenues have increased every single month ahead of projections. The August projection, they collected about $70 million more than they projected. And so they're gonna be flush with cash. We just don't know. We'll hear more about what's gonna happen with the election, and that'll set the tone for the agenda. They were able to reach agreement on a few bills, and I'll briefly mention them. They continued a health insurance premium finance plan to help buy down the cost of health insurance premiums in Minnesota. That was about a $300 million price tag on that program, and they did pass that. They did refill up the unemployment insurance trust fund, which affects all of you as employers. Without doing that, that was about $1.5 billion. Without doing that, an assessment on everybody's unemployment insurance would have gone up, and all employers would have paid that. We ran a huge deficit in that unemployment fund during the pandemic, and that needed to be paid back, and they were able to reach an agreement on that. And they did reach an agreement on, and maybe some of you worked on it, but the opioid settlement, much like the tobacco settlement, these funds that are coming to the state through the opioid settlement, and how they would distribute that to municipalities and tribal government. But beyond that, it was pretty meager. And for the biennium, for 2021 and 2022, they only passed 99 bills to the governor. And to put that in perspective, in the heydays of lawmaking, when Wendell Anderson was governor and they passed all kinds of bills, the legislature would send 1,200 bills to the governor. 99 bills is what went to the governor in a 2-year period. So cooperation is not in a great supply at the Capitol. A couple of things that also passed that may impact your practice. They extended the COVID-19 presumption for first responders and healthcare workers so that if they contract COVID at work, it would be presumed that it's an occupational disease. And they extended that until January 13th of 2023. After a series of egregious stories in the Minneapolis Star Tribune about some very predatory practices for people that were buying structured settlements that many of you work out for injured clients or for your insurance clients that are paying claims to injured people. These stories were just horrible of how people would prey on these, buying them for 10, 12 cents on the dollar. And the lack of disclosure and court oversight over that process was glaring and graphic. And the legislature did respond, and they did pass a law in the 2022 session that kind of changes that practice, and we hope for the better. The most important thing, and I worked on this bill a lot, the most important thing that they did right prior to August 1st of this year, you went to court and there was no independent evaluation of the sale of your settlement, and the standard is if the person who owned the settlement and was trying to sell it thought it was in their best interest to sell it. Well, they're in front of you. There's no adversarial party. It's the purchaser and the seller asking the judge to approve the sale of their own asset. They've changed that now, so that now the court has to make a determination that it is in the seller's best interest to do this. It's in their best economic interest, and it really rarely is for them to sell their long-term structured settlement payments. It also provides greater disclosure to the consumer when they are making this transaction. They have to express this to them in the form of a loan. If you were going to the bank and borrowing this money you're giving up, you'd be paying 182% interest, right? In terms that consumers can understand, and we think that's a good thing, that they're going to have better disclosure there. And so that is one of the things that did pass in the civil law area that we think is a positive. A couple issues that didn't pass but got attention that I think we're going to hear again about in 2023. There's a major push by municipalities to change how we treat first responders, police officers, firefighters who have PTSD, and how their claims are handled and processed and the treatment that they may get. There have been a number of instances of first responders. Minneapolis is not the only example, but I think they have over 200 PTSD claims that have been filed in the last 18 months. And it is a heavy cost on local units of government, and they would like to have a better way to provide treatment to their employees. And that was a major issue in the session. It didn't advance, but I anticipate that is going to come back. For those of you that are doing car accident and motor vehicle cases, there was legislation that was proposed that would regulate and require insurance coverage for this new business model called peer-to-peer car sharing. And, you can put your car on the market right now by Car2Go, or and somebody else can use your car when you're not using it. And there's questions about who's got primary coverage in that situation. Does the person renting the car have it? Does the platform have it? That did not advance after the first committee hearing, and there were some real problems with how the bill was written. But I think that's an issue that is ripe for legislation. It does need to have some parameters put on it. I will say this, it was a bill that everybody hated. It was fun to go up as trial lawyers, and sometimes we stand alone. But the rental car companies and the auto dealers and the insurance company, everybody hated this bill. So it was nice to have some company for a change on something that we opposed. They once again had a hearing to repeal the seatbelt gag rule. I think I've testified on that bill about 41 times in the last 20 years. I assume that they will attempt to do that again. And the last thing I will mention is the Minnesota Medical Association has approached MAJ about an alternative form of dispute resolution when they have an adverse event in medical care. And it's called candor. A couple other states have passed this, and they want to have a mechanism where they can deal with their patients in a way that doesn't that isn't held against them, so that they can speak with them in candor. This is what happened, and it's a voluntary process. And that didn't pass in 2022, but there are some positive aspects to that program that I think we all could agree upon. And so that's an issue that I think if you're doing medical malpractice work, that I think is going to surface in 2023 and may get attention. So I'm going to turn it over to Jeremy here, but as Jim mentioned, we are in the middle, about 47 days to go to the midterm elections. And, you know, Minnesota, electorally, we're a little crazy, but we're not that crazy. So I don't know exactly what's going to happen in the election, but we do know this. In 15 of the last 16 presidential elections, Minnesotans have voted for the Democratic nominee for president. And at the same time, in 15 out of the last 16 state elections, our voters have produced divided government. So there's a message there. Only one time in the last 16 election cycles did we have full control of our government in one party. And that was in 2012 when Governor Dayton was in office, and the 2012 election produced majorities for the Democrats in the House and Senate. Every other election of the last 16, we've produced divided government. And I think that that is not an accident. I think Minnesotans like divided government. I think they like checks and balances. And the other just brief thing I'll mention with the new legislative district boundaries that were redrawn by the courts, they were not part of the partisan gerrymandering that you've seen across the country. Everyone has kind of said the courts did a very good job of redrawing the lines without regard to partisan makeup or where the incumbents live. I'm a little biased. My brother was on the 5-judge panel that helped redraw those lines, but I think that they did a good job. But what has happened in Minnesota over the last 20 years, we have gone through a very significant political and geographic alignment, and that is reflected in the new legislative district maps. You are seeing a concentration of voting power in the core metropolitan area, the 7-county metropolitan area, outstate regional centers, Rochester, Moorhead, Duluth, and that has made it extremely difficult for Republicans to win statewide. You know, you're winning your margins in Hennepin County for a Democrat. You're winning Hennepin County, the most populous county, by 40 points. And we haven't had a Republican win statewide since 2006. And I think that that is a reflection of the geographic and political realignment that Minnesotans have experienced. So, you know, that you just can't ignore it. That is where the votes have shifted, and I think that's going to continue in 2022. So with that, Jeremy, I'm teeing that election up for you, and then hopefully we'll be able to have a chance for questions. And thank you again for having me here. I always appreciate being invited to come and speak to this group. So thank you, and thank you for what you do.
Well, thank you, Joel, and thank you, Brett and Jim, for having me. The seatbelt gag rule is one of my clients' bills, and Joel likes to beat me up on it every single year, and so to that point, you've got some pretty capable representation here. Frequently, I represent folks on the other side of some of those discussions at the Capitol, and Joel always does a great job representing those of you who are part of the association. I also want to talk to your brother, Joel, because I live in CD8 now, or I will. I live about 3 miles north of White Bear Lake, and so what I have in common with the Iron Range and International Falls and some of those things I don't entirely know, but nonetheless, I now live in CD8. When I listen to election previews, I always hope that somebody gives me, you know, some crystal ball indications, but I think if I've done my job at the end, you'll be as confused as I am, just with more facts. To Joel's point earlier, the geographical and political shifts, in addition to that, the whole world has gotten more partisan, and there's this purity test now that exists among the party faithful on both sides that probably didn't exist, or maybe there wasn't a mandate quite like there was before. And so we've seen fracturings within caucuses. You now have these subgroups within the House Democrats or the Senate Republicans or whatever the case may be. And we saw that even play out into how they caucus. Some getting kicked out, some, get this, there were at the beginning of 2022, maybe it was 2021, there were the Republicans in the House, then there were the new Republicans in the House, and then there was a guy who was too nuts for the new Republicans that they kicked out, and he had to have his own group. And the worst part about that is I think he's probably going to get reelected. The gentleman who was ostracized from the House DFL party lost his primary. I don't know anything about the new person, but anyway, it's messy. The reflection of what you see on Facebook, it translates to the Capitol to a certain extent, and it's messy. These folks, Joel mentioned not a lot got done. On the one hand, that's too bad. On the other hand, thank God, because if the stuff we wanted to get done got done, so would a whole bunch of other things. And last year, the recipe just wasn't there. The fact that they couldn't get together around a massive surplus and just do some sort of feel-good election spending, couldn't send the Walls checks back, couldn't do some middle class or low-income tax relief. I mean, there were two pretty good plans out there. It was telling of the fact that these purity tests have just gotten in the way. Now, 51 people are not seeking re-election. It was 1972 the last time, the only time more people didn't seek re-election. And I'll be honest with you, I think a lot of it has to do with the fact that people are tired of the fighting. It's gone from sparring and the way politics used to be conducted, families got left out of it, to this social media evolution where there's a bunch of people who make money delivering body blows. And when I talk to people who have decided to retire, it has a lot to do with the fact that they don't want to go through it anymore. You know, it's a part-time legislature. They make 40 grand or something like that. And it's just not worth it. And it's no longer, despite what the Constitution says, it's no longer part-time work. If you're in a competitive House seat, there will be probably this cycle $3 to $4 million spent on one House seat, 134 of them. So it's gotten tough. And so, you know, they all left, but in reality, I think they felt like they were getting out of the asylum. There were a bunch that this year just threw their hands up and said, you know what, this is not what I signed up for. And people with a lot of experience, it's always a tricky spot for folks who like to think about how our governing system should work, about the institutional knowledge versus term limits. And we're losing 600 plus years of experience this cycle, and that means something. Joel mentioned the redistricting. This is a shot of the House maps. They've changed over time. 2012 on the left, if you're in the back, 2020 on the right. There is a plan that, I don't know if there's a pointer on this deal. Right here is the last holdout of light blue in greater Minnesota. Kurt Doubt, who's the current leader of the House Republican caucus, believes that without a single suburban seat flipping, they can take a narrow majority by just winning all of the greater Minnesota seats. And now that doesn't include Mankato or Rochester, where folks who caucus with the DFL already have seats. It does include a Paul Marquardt seat up in the northwest part of the state and a few seats up in the northeast part of the state. And one thing that's worth pointing out, I think, is that the Senate DFLers, longtime DFLers, Tom Bach and David Tomassoni, who have been the quintessential DFL, particularly L in that equation, started caucusing with Republicans this year. And if you ask them, they would say, we think just like we've always thought. But there's a group in Minneapolis now driving the party politics who have succumbed to the purity tests that make it impossible to negotiate, arrive at deals, so on and so forth. And for reasons that I'm not going to try to explain, they felt it was more beneficial for them and their constituents to caucus with Republicans. It would not surprise me at all if Kurt Doubt is right and they pick up those 3 or 4 greater Minnesota seats that they don't currently have and probably flip a few in the meantime. In the suburbs, I'm sorry. Okay, so every election has a unique fingerprint, but there are some basics. Joel talked about some of the basics. Presidential midterm, almost always good for the opposite party of the president. I'm just going to mention a couple of things that I think are unique to this particular cycle. Well, let me back up. money. In Minnesota, Democrats always outspend Republicans. We end up in this purple situation, like Joel mentioned, 15 out of the last 16 cycles, and that gets done with Democrats typically outspending Republicans at least 3-1. I would expect it to be more this year, and the reason I say that is just a gut check. You've seen all of the ads running, the independent expenditures running against Scott Jensen and some of the Republicans. Those things have been on the airwaves now for going on a month, and the Jensen campaign just got on air, I think this week, or maybe at the end of last week. The IEs against Walz aren't going to put anything on the air till probably at least next week. So there's just a time factor there, and Republicans in this state have a hard time raising money, particularly since I think it was 2006, the Emmer kerfuffle, when Tom Emmer ran for governor and lost to Mark Dayton. He made some enemies with the corporate community. He's obviously gone on and had a successful political career in Washington, D.C., but that set a stage that I don't think we've been able to recover from. Here's what I see as the exposure and the tailwinds. The exposure for Tim Walz is his record. He inherited a bunch of stuff that I wouldn't wish on my worst enemy, but he also made a bunch of decisions that a lot of Minnesotans don't like. Okay, so you tack those onto the nationwide themes of, you know, abortion on the one hand and economy and crime on the other. Jensen, on the other hand, undisciplined. He's run for one seat. He's held a Senate seat for a little while. And keep in mind, when he was a senator, he was the left flank of that Republican caucus and real mavericky. Well, his maverickiness has extended into his campaign. On the other hand, Walz, the tailwind for him is money. He's got a bunch of it, the power of the incumbency. I think he's always done well in front of a camera. He's very affable. People like him. But for Jensen, you know, his strongest attribute, and I don't mean this as a dig, he's not Tim Walz. He doesn't have the record that he's got to defend right now. Though, as you've seen in the IEs, if you've paid any attention to TV or social media, he is, you know, the Antichrist when it comes to abortion issues. And those ads have been very effective, and there's been some polling to indicate that. Speaking of polling, I don't take it particularly seriously. It's fun. It's kind of like reading the opinion pages. It's a snapshot in time. But what I do think is interesting is that RCP, which is, if you follow politics at all, there's a website called Real Clear Politics. They do a good job aggregating and finding averages in polling. Those things seem to tell us a little bit. What RCP has now is a Walz +5 advantage. That's pretty unheard of for Republicans. That shouldn't be good news for Republicans in Minnesota. That's good news for Republicans. Never that high. Nate Silver, on the other hand, if you follow his baseball predictions that have turned into political predictions, he is giving Walz the same chance that he gave Hillary to win in 2016, 95-5. RCP, on the other hand, has it as a toss-up. So internal polling from the Jensen camp, the Walz camp, the Democrat caucuses, Republican caucus, have things pretty well in toss-up territory, which in shorthand in Minnesota elections generally means pretty good things for Republicans, but there's a long time till we get to the election. Speaking of split government, Joel mentioned, he was talking about what this weighted map shows. So imagine you're a statewide Republican candidate. Well, you can just forget about it, roughly a third of the state, more than that, but you can just forget about it. You've got to go find votes in all kinds of other places. It means traveling a lot more. It means spending a lot more money to try to target your message, so on and so forth. I know that Attorney General Ellison is coming later. Not only has Minnesota divided government, this is a year where Minnesotans turn out and vote. They're more educated voters than most other states. I would not be shocked this year if there was something among the constitutional offices, governor, attorney general, secretary of state, auditor, where the parties split among them. And how that works for governing, for guys like Joel and I trying to figure out how to engage with the administration is beyond me, but it'll be an interesting problem if we get it. Joel talked about some of the scenarios there, but I think for the hyper-partisan folks among us who hope that their team wins it all, Well, we saw it once in the last decade, and it wasn't that great. It was kind of terrible. They had a hard time governing. Minnesotan stakeholders, voters, and legislators, elected officials, are used to divided government, and they kind of know how to make it work. Let's take 2022 as a flyer and set it aside. It's generally been in everybody's best interest to see that happen. And like Joel said, it would not surprise me if that happened again. Finally, if you want to get involved, I'm sure that we can provide you some resources, but just Google candidates in your area. They'll put up a sign in your ditch. You can knock on doors. You can make phone calls. There's a now retired legislator who, for those in the back, Sandra Erickson up in the Princeton area, she ran this sign. All right, this is electoral capitalism at work. You can drill in my yard if it will lower gas prices. Sandra Erickson, and we all thought that was a really bizarre ad, but she kept getting reelected. So with that, I know we're running long already, and I hate to be responsible for starting off that way. So a couple questions? Or no?
Does anyone have any questions or issues you want to raise? Well, as usual, they both did a great job, and I'm very grateful for you guys coming. Thank you.
Yeah, thank you.
Okay. Good morning, everybody. So thanks for coming. Those of you that came and those of you that are here in past years know that the rest of these seats would be filled and maybe next year for that, but we're doing well. Mary Batchelor is up next. She's going to talk about confidentiality agreements. And the one great thing you can say about Mary, unlike everyone else in this room, especially me, she was number one in her law school class. Anyone else? Number ones? Don't be bashful. All right.
That's not the only good thing you can say.
Well, it's one of the things that I know about you that's true. So anyway, Mary Batchelor. Oh, and Mary is, she's originally from Fargo, correct?
Well, I live in Fargo.
She lives in Fargo. Pete Kessner, who was here, Pete wandered out there, I think, but Pete brought her down here virtually, it sounds like, with his firm. So, and Pete's been a regular contributor here. So, Mary, have at it.
So one of the problems with having a really cool PowerPoint that doesn't have any words on it is that all my notes are not available to me apparently. So I'm just gonna put my computer right here so I can read my notes. So as Brett said, I'm gonna be talking about confidentiality agreements, and I work with Pete Kessner, PKM law firm. We represent people who've been injured by commercial motor vehicles, semis, that sort of thing. And so today we're gonna be talking about the problems basically with some of these confidentiality agreements. I'm gonna talk about basically the basics, and specifically what I'm talking about, some of the reasons that they're used and some of the ways that they're used. I'm gonna give you a case study based on a real world example of a case in Michigan that was presented to the Michigan Ethics Board, and the ethics opinion that was provided there, and some of the ethical implications of that. And then we're gonna talk about some public policy considerations that these confidentiality agreements bring to bear. First of all, the basics, what are we talking about? Obviously, I think everybody here has dealt with confidentiality agreements, and specifically what I'm talking about here is a contract that attempts to limit the attorney's ability to talk about the settlement. So obviously, all of these situations, there's a released party, offers money in exchange for promises from the releasing party, including a release of liability, among other things. And plaintiffs are often asked to sign these in the context of personal injury cases, trucking, mass torts, products liability, basically any situation where there's a corporate defendant especially, and a corporate defendant wants to prevent the settling party, the plaintiff, from talking about the terms of the agreement, talking about the facts of their case, certainly talking about the amount of money that they were offered, but also to prevent evidence of those bad acts getting out in the public. And so the main reason for using them is exactly that. Corporations want to prevent bad publicity and the perception of frivolous lawsuits or copycat lawsuits. So encouraging in their mind other plaintiffs from bringing claims against them because there's this perception out there that they're gonna offer a lot of money in exchange for silence, without admitting liability, of course. So that's why defense typically wants to use them, and they work in a lot of cases because the defendants are the ones that have the money. The corporations and the insurance companies have the money. The power is in their hands, and so they're able to use these to their advantage. Why do we not want to agree to them? There's a lot of ethical considerations that come into play, and we're going to talk about that. There's also other implications too, practical and tax implications. They have a tendency to harm the public and inhibit the proper functioning of the justice system, which is something that as attorneys we commit to uphold those values of upholding the values of the justice system, so that's a problem. And they really, there's also several public policy reasons that you don't want to use them. And they limit your ability to practice law, and that's a big thing that we're going to talk about. They can, though, be used ethically and effectively in a very narrow way and in a narrow scope. And I'm going to provide you with kind of a guiding principle to think about when determining whether you should be agreeing to these kind of agreements. So I'm going to give you a case study, like I said, and this is an actual case that happened in Michigan. And a plaintiff's attorney provided this factual scenario to the state ethics board, which then issued an opinion. So this is dealing with an exploding kitchen appliance. A plaintiff's personal injury lawyer is faced with the following scenario. The lawyer's client is the widow of a man who died when a kitchen appliance exploded during normal use. So the case mediated for $2 million. And the lawyer feels that this is a fair approximation of what the case would generate at trial. This is in 1998, by the way. Discovery has disclosed that many other individuals have died under similar circumstances, and the appliance manufacturer had knowledge of this. The manufacturer could have cured the defect in a design with a 50-cent part, but chose not to do so for financial reasons. So, $2 million at mediation. After mediation, counsel for the appliance manufacturer offers to settle the case for $3 million, subject to the following conditions. The court file must be sealed and the terms of the settlement must be secret. Plaintiff's counsel must agree to return all discovery materials and not retain copies. The expert witnesses lined up by plaintiff's counsel must agree to not testify in future similar cases. And plaintiff's counsel must agree to not represent any new clients in similar cases against the appliance manufacturer. So, the offer is communicated to the client who wishes to accept immediately, as you can imagine. And the client's not concerned about any of these conditions since they don't directly affect her. The lawyer, however, is concerned and does not want to accept this. And you might be able to guess what some of those reasons are. And I'm going to get into that, specifically the ethical considerations. But even before that, there's some other practical considerations and tax implications as well. And anybody who represents plaintiffs probably knows that under the Internal Revenue Code, compensation for bodily injury is not subject to taxation, subject to income tax. But in this case, arguably, that $1 million difference was not in compensation for bodily injury, but in compensation for silence, okay? So there's the potential that there could be tax implications on that $1 million, and that's something that you would need to counsel your clients on and consider. There's also some practical implications with some of these provisions, And not all of these provisions were found to be unethical by the Michigan board. For instance, the provision that plaintiff's counsel return all discovery materials and not retain copies. This is actually something that the Michigan board said that could be ethically accomplished. But there might be some other considerations you might want to think about. One would be, whether there's potential privilege or work product issues involved there. And then whether or not you're subjecting yourself, if you are if you're concerned about a potential legal malpractice claim, there's a 6-year statute of limitations in Minnesota on a legal malpractice claim, and so you might want to keep your file for at least 6 years just to protect yourself in that situation. So those are some not necessarily ethical considerations, but other things that you might want to think about. The other provision that was not necessarily unethical according to the board was that the court file be sealed. This is something that you're going to have to get agreement from the court, obviously, but that is something that could potentially be done ethically as well. But there are lots of ethical implications with respect to the other provisions, and so we're going to look at the ABA model rules of professional conduct, which I'm sure everyone here is very familiar with. So the first thing that comes up in these situations is your duty to your client. And this is the big one. We all know that duty to clients is first and foremost. And in fact, Rule 1.2a says that a lawyer shall abide by a client's decision whether to accept an offer of settlement. So if you're just looking at that rule, it's a no-brainer. You should accept this offer of settlement, right? And that's what the client wanted. Rule 1.3 also says that a lawyer shall act with reasonable diligence and promptness in representing a client. The comment to that rule states that a lawyer should pursue a matter on behalf of a client despite opposition, obstruction, or personal inconvenience. So even if this is personally inconvenient to you, maybe you should accept it anyway. Unfortunately, this rule has to be read in conjunction with the other rules of professional conduct. And the big one there is that not only do you have a duty to your existing clients, but you have a duty to former clients, you have a duty to future clients potentially, and you also have this conflict with your ability to practice law and restricting your ability to practice law in the future. So it's not as simple as it looks. And Rule 5.6 is the one that comes up in pretty much every single ethics opinion you're going to read, and in every potential scenario in terms of putting any sort of restriction on your right to practice in the future. So a lawyer shall not participate in offering or making an agreement in which a restriction on the lawyer's right to practice is part of the settlement of a controversy between private parties. So as you can see, this is in direct conflict to the idea that you accept the settlement if your client wants you to. And I think one of the really interesting things about this rule is it says a lawyer shall not participate in offering or making an agreement. So if you're offering an agreement that restricts another attorney's right to practice, you're also violating this rule. Okay, so keep that in mind. If you're a defense attorney and you're putting this in front of a plaintiff's attorney to sign, you're actually violating the rule just by offering that. So the comment, one of the comments to this rule also prohibits a lawyer from agreeing not to represent other persons in connection with settling a claim on behalf of a client. So you're actually explicitly prevented from agreeing to not represent future clients. And why is that? One of the foundations underlying the model rules of professional conduct is to make legal representation available to as many people as possible. And by restricting your right to represent people in the future, you're obviously violating that. And not only obviously are you doing that, but you're also affecting your livelihood and putting yourself in a position to not get future clients, which you don't want to do either. Rule 1.7 piggybacks on this too. So this rule prohibits representing a client where there's a significant risk that the lawyer's responsibilities to a former client will materially limit the lawyer's representation. So if you're getting, if you're seeking new clients that are going to be bringing claims against the defendant that you already signed this agreement for, you're going to be putting yourself in a position to have a conflict between a potential future client and a past client. How can you represent a new client without discussing anything that you've learned in the past, or any evidence about that client, about that defendant, information like their policies and procedures and practices, information like the existence of certain types of evidence? You're going to be basically reinventing the wheel every time you have a new client. And so not only is it impractical, it's probably impossible, as well as unethical. And you may also want to share this information with a mediator or some other neutral when you're presenting your case in mediation or a settlement conference in order to help resolve the case. So these are all reasons that you might need to use that information, and it's going to materially limit your ability to represent your client if you can't share any of that. So that basically takes care of the provision that was that a plaintiff's counsel must not agree to represent any new clients in similar cases. There was also a provision with respect to evidence. So Rule 3.4 governs fairness to opposing party and counsel, and basically tells you that a lawyer shall not unlawfully obstruct another party's access to evidence. And evidence does not belong to any particular party, and either do witnesses. So in this situation, it's against the rules, and it's completely unethical to say that you're not going to allow an expert witness, for instance, to testify in the future. So you can't really do that anyway. I mean, you can't, under the rules, prevent someone else from providing evidence to another party either. And party in this context is construed broadly to mean not only an existing party to the litigation, but also a potential future party. So a potential future litigant, someone who could have a claim against this defendant in the future. You are not allowed to restrict their access to evidence. And even if you wanted to, let's see, this rule tells you that a lawyer shall not request a person other than a client to refrain from voluntarily giving relevant information to another party, unless, and there are a couple exceptions, or there's one exception, the person is a relative or an employee or other agent of a client, and the lawyer reasonably believes that the person's interests will not be adversely affected by refraining from giving such information. And so this is used to prevent someone who's an employee from sharing maybe confidential information or trade secrets or some other piece of information that they would have by virtue of the fact that they're employed by the defendant from sharing that in the future, if you believe that it won't adversely affect their interests. So that is something that you can ask them to do, but only in that very narrow case. So as you can see, lots of ethical considerations and potential problems that arise with those provisions that were requested in that Michigan case. And the main one is the restriction on your right to practice law. And the public policy concerns that underlie that, the main one is really restricting the public's access to the best attorney for their particular case. So attorneys with the most experience handling certain types of cases shouldn't be prevented from using that experience and using that knowledge and using that expertise to benefit people in the future. Obviously, that affects your ability to make a living, but it also affects the public and their ability to pursue justice. So, you know, it's contrary to really the spirit underlying the criminal or the justice system, as well as the model rules of professional conduct. These agreements are also seen as an effort to kind of buy off plaintiff's counsel and bribe, for lack of a better term, litigants into settling. And then it also places the attorneys in a position where the interests of the current clients are in conflict with future clients. And I think that, I skipped a slide. So it's important to note, though, that, you really can ask for these and you can agree to them in certain limited situations. And I found this guiding principle in one of the ethics opinions that I think, sets up sort of the rule that we can use to determine if these agreements are ethical or not, and that is that a claimant's attorney should not agree to or request a settlement restriction giving the attorney significantly less discretion in prosecution of a claim than an attorney independent of the agreement would have. So you can use this as kind of a guiding principle when determining whether to sign one of these confidentiality agreements or to offer it in the first place. And the opinions that I've read that are out there, there are narrow clauses that you can include that are held to be ethical. And a lot of times, most times, just the existence of the settlement and the terms of the settlement, including the amount, that can be held confidential in an ethical manner, as long as that's not publicly available information, obviously. We may not want to do that, we may not want to agree to that, but it has been found to be ethical. And in the same way, certain non-disparagement clauses, if they're narrow enough, have been found ethical as well. And I think, in the way that this often comes up is kind of at the last minute, right? And it's just like the situation that I used as the case study in Michigan. It was at settlement, or it was at mediation, and then it was after mediation that this was presented to the attorney and to the client. And at that point, it's kind of too late, and the attorney is put in a position to really be pressured by their client to do the right thing by their client, but also to uphold their ethical values as well as what they feel is in their best interest. And so really the way to hopefully prevent these from coming up at the last minute going forward is really to talk to your client right away and to talk to the defense as well and tell them up front that you're not going to agree to these kind of settlement agreements. At least then the expectation is set on the front end that hopefully they won't spring this on you at the last moment and put you in that pressure situation where you feel like you're in a tough spot with your client. So with that, any questions? I know this is a very interesting topic.
Oh, it really is.
Well, I know it is. That's why I said that.
I'm multitasking and actually thinking of some things, and then not sure I should ask them because you probably already said it, so.
Well, that's okay. I don't mind repeating myself. Yeah. So the question was, would it be prudent to have some sort of separate agreement with consideration stated for the confidentiality aspect of it?
Just separate consideration, not a separate agreement.
Okay. Maybe. That's an interesting suggestion. Sure. That might help from a tax perspective, as you said. I think, generally there's no question in a settlement agreement that the settlement amount is for bodily injury. So it shouldn't be a problem unless it's obvious in a situation like this that the only difference is the secrecy clauses. So it shouldn't typically be a problem, I don't think, but in this situation, that might be prudent. I don't know if anybody else has a suggestion there, or just don't ask for it in the first place, I guess, but yeah.
Another way around it is put in that it's mutual confidentiality.
Well, and I think, I mean, and again, the real issue here is that the attorney is the one that's being asked to maintain confidentiality. So it's not uncommon for clients to have to maintain confidentiality, and some of them may want to do that anyway because it protects them too. So I think that here the real issue is the attorney making that agreement. And the attorney can also be held liable on behalf of their client if their client breaches the confidentiality clause, unfortunately. So it doesn't, leave you completely in the clear if it's only signed by the client, but the real problem comes when the attorney is the one that's signing these. I don't know if that answers your question or not. Okay. You're welcome.
By staying on schedule, Mary, you've potentially earned yourself a repeat visit, so nicely done. All right, next up, we are pleased to provide you with your annual hour of ethics. And actually, I could have probably petitioned for another half hour because Mary's presentation dealt with ethical issues as well, but I will not be petitioning. I have petitioned and lost with the lawyers board even when I was on the board. So anyway, so our friends from the Bassford firm, Aram Destian and his was summer associate and now back at school, right? All right, Olivia Lisfonce, and just Aram, so you know, you are going to be the winner this year of the Not Standard Sport Coat. So in case you ran out of here after you're done like you're prone to do in past years, I will be emailing you that certificate, but this is at least 4 or 5 years for you guys, and I know we gave it to Jessica last year, the year before, and I know you're now a shareholder at the firm, so congratulations there. I feel like we might have had something to do with that, pushing you up the ladder at the firm. So anyway, and I was down in Northfield yesterday, and my son goes to St. Olaf, and so I figured it should go to an Ole this year. So anyway, congratulations on that, and come on up and let's have some ethics. Oh, one other thing. Veritext Paradigm out in the hallway, one of our sponsors, they've been with us for a long time. Jan Ballman's back, by the way, for those of you that know Jan. They're going to raffle off a pair of Viking tickets to the Lions game this week and to one of you lucky winners. And so make sure you get your card in their fishbowl out there. Okay.
Well, thanks, everybody. It's good to be back. I'm Aram Destian from Bassford Remley. I'm a shareholder there. My practice primarily consists of complex commercial litigation, and then the other half is representing lawyers in ethics, malpractice, and risk management issues. So I'm very happy to be back. For those of you who've been here in past years, you'll know that I usually present with my partner and good friend, Jessica Klander. Jessica is in San Diego right now, and when I suggested that she pay for all of us to go out there and do this there, she thought that was a bit much, and so I'm bringing along my other colleague, Olivia, who was kind enough to, as you guys all know, do all the work in preparing this. So I figured let's actually let her come and talk, and she knows more about it than I do, frankly, on the facts of these cases. So I'm very happy to have her here with us. Do we have the PowerPoint up? You don't have one? All right, well, hold on one second. Thank you very much. Mind if I grab that? Thank you. So what we're going to try and do when we get our PowerPoint, I think we'll get that taken care of in a couple seconds here. We're going to go over a couple of things. We're going to go over some recent developments in legal malpractice law, some recent decisions in legal ethics and risk management issues, and then we're going to talk about some hot topics. What I generally try to do with this, aside from scare all of you into, paying attention to the P's and Q's of ethical compliance, is identify the things that I've seen in the past year as being common issues raised in disciplinary investigations or risk management issues that I've seen. I serve as Associate General Counsel for our firm, and so I see things in that capacity. I represent dozens of lawyers a year in dealing with ethics issues and malpractice issues. So these are things, especially some of the stuff that we'll talk about in terms of fee agreements, that will that are very, very common in the cases that I've seen. So while we wait for our PowerPoint to come up, I'll have Olivia come up and explain the first case that we're going to talk about. And it's the Supreme Court iteration, the final end of a case we've talked about, I think, 2 or 3 times now, which is the Middlestead v. Henney case, which is a legal malpractice decision that we finally got final clarity on a pretty important issue for those of us who defend lawyers and for those of you who may sue lawyers. So I'll have Olivia come up and provide some additional explanation of that.
All right, so Middlestead v. Henney. So the expert requirement for the malpractice claim under the Minnesota statute 544.42 provides 2 things when a plaintiff brings a legal malpractice claim. First, submit an affidavit of expert review with the complaint. And then a more detailed expert disclosure that sets out the opinions of that expert on the claim within 180 days after discovery has started. So briefly, Middlestead involved allegations that an attorney represented the plaintiff, Middlestead, in a business transaction and failed to disclose to Middlestead that he was part owner of the owner party of the business transaction. So when the dispute arose, the parties to the transaction, Middlestead brought a claim for breach of fiduciary duty. Because Middlestead did not submit an affidavit, the court rejected the court granted summary judgment, I apologize. And the argument was that it was a breach of fiduciary claim versus malpractice. So there was a distinction there, which the court did not buy.
Yeah, and so what's the important part about this? I mean, it's inside baseball, and for those of you who don't either sue or hopefully get sued, it's good for me but bad for you. What's important about this is it's a couple of things. One, Minnesota has a 6-year statute of limitations, which you heard the prior speaker discuss, right? And so one of the things that has been created by the legislature in order to, given that this goes on, you've got a tail on these claims for quite some time. I mean, it's 6 years from the accrual date, and our accrual date in Minnesota isn't the date that the work was done. It's actually something, it's called the sum damage rule, which requires some analysis as to when legal rights have changed. So it could be multiple years after the work was performed. So it's not inconceivable that you could have 8 years, 9 years, even since the work was performed for a claim to be brought. So because of that, the legislature has imposed these restrictions that require someone to vet the claim and determine it to be non-frivolous. It's important for a number of reasons, but what I have been seeing is it's not uncommon for plaintiffs' attorneys in these types of situations to bring claims attempting to split them and allege that they're effectively different. And this claim, or this case here, has assisted us in saying, well, look, that may be partially true and that there can be different relief available under breach of fiduciary duty claims, but where you're alleging a breach of the standard of care effectively, it doesn't matter which term you use. You have to get an expert to vet that and determine that, in fact, there was a breach and there was causation. Great, here we go. Perfect. All right, and then the next thing is a couple of new ethics decisions that came out. This is the majors decision. I'll have Olivia explain a little bit about this one and then I'll tell you why this scares the heck out of me.
All right, so in re disciplinary against majors, the misconduct arises from 2 separate client matters. The first client matter, the client paid advanced payments, and the attorney deposited that into a business account, into the operating account versus a trust fund or a trust account. Throughout the representation, the attorney withdrew his business account to pay business expenses such as payroll, and this led to repeated shortages And there were times where the account didn't have enough funds to cover the client's advance and unearned expenses or funds. In the second matter, the attorney represented a client who agreed to a flat fee agreement, which stated that the legal fees would be held in a trust and would not be refunded if the client terminated the agreement. However, the agreement didn't provide the 5 non-refundable fee agreements required by the Minnesota Rules of Professional Conduct. So the key in these two matters is that the flat fee did not comply with the agreements that is required when you have a flat fee agreement, and advance fees going into the operating account versus the trust account.
So I'm gonna talk about this for a little bit, because I'm seeing this a lot. This here is the rule that deals with flat fee agreements, all right? If you use flat fee agreements and you have not reviewed them for compliance with this rule, you are sitting on a liability problem that will explode the minute you get any type of complaint, because the first thing that an OLPR investigator is going to ask for, no matter what the issue is, if there's an allegation that it's a flat fee retainer agreement, is they're gonna ask to look at your retainer. And so let's say you have a complaint against you for, you didn't respond to my emails fast enough, all right? I see that all the time in representing lawyers. The OLPR is not limited to investigating what has been alleged in the complaint. Once a complaint is filed, if an investigation has been opened, it's open season. And what I very, very frequently see, all right, is exactly that fact pattern. You have somebody who says, my lawyer didn't respond enough. Or frankly, I have had some crazy allegations that they were conspiring with the county attorney's office and all these other things. And for some reason, it got sent to a district ethics committee for investigation, even though it seemed on its face to be one that you would want dismissed. And despite all of the actual allegations being found to be completely without merit, there is a private admonition issued as a result of the fact that there is a fee agreement that has been used in that case that is not compliant with this rule. So you can have everything right over there, and you can have a huge, or not a huge problem, but a problem over here. On its own, this is probably a private admonition, okay? Here's where it gets bad, and here's where the major's case is illustrative, all right? Oftentimes, people don't realize that they don't have a non-compliant fee agreement. They think they're allowed to do this, right? They think, well, all right, I'm allowed to do a flat fee. And they don't include what I call the magic language. These 5 provisions here at the bottom are absolutely mandatory for every flat fee agreement. And if you want to place your flat fee into your business account and you do not have these, right, you can't do that. It has to go into trust. It is not, if you do not comply with this, it cannot be your property upon payment. It can't, as a matter of rule. And so what happens is people place them into their trust accounts, or into their business accounts without putting in their trust, and there's a problem, right? The really big problem then comes when they've said, all right, I'm gonna do this for $1,500 plus expenses, right? So $300 in costs, and they give you an $1,800 check. You've got a non-compliant fee agreement, you put it in your business account, and you include the $300 as your advanced costs. You've now misappropriated funds because you've placed advanced costs, which should never go in your business account, into your business account. And if you draw that down below the balance, so let's say it's $300, if you draw that down to below $300 in your business account because you're paying your normal expenses, that's intentional misappropriation that the court takes a presumptive, the default position is disbarment. I just had one of these where it was entirely unintentional, and we had to stipulate to a 12-month suspension because absent litigation, that is the lowest the OLPR would go. When there was an agreement that there was absolutely no intention to steal the money. But the way that the court has defined the terms intentional misappropriation means if you put those advanced costs into your trust, into your business account, and you draw it down below that value, you have intentionally misappropriated funds. I've seen 3 of these now in the last 2 years, and they are brutal. They're career enders, and they're almost always unintentional. So, what do you have to do? All right, first off, your first thing, you need to vet every one of your flat fee agreements to ensure that they comply with this rule. There's no such thing as a non-refundable flat fee. There's no such thing as a non-refundable fee agreement. That's just not a thing. The rules are very clear about that, all right? If you do a flat fee and you terminate before, if either you terminate or the client terminates you before the full amount of work is done, you, by rule, must give them a refund of some amount that is reflective of the work performed up until the time of the termination or withdrawal. In fact, as you see here, it says, will be entitled. That is a must. That is not a permissive. So if you get the case literally up until the last possible thing and you get fired, right, and you've done 98% of the work on that case, you have to give them something back. It may be $20, but you have to give them something back. There's no way unless you've completed all of the services for you to keep the entire amount. All right. So that's number one. You're going to vet your fee agreements, and I do this for so many of. I serve as outside ethics counsel to 15 law firms now. This is everyone. Every time they want to do one of these with a new fee agreement, I vet it, because these are, especially if you have a consumer-facing practice, you're going to get an ethics complaint just based purely on the fact that you have clients who think that they should have won. And so there's going to be an ethics complaint, and this is the trigger, okay? So that's number one. Number two, you need to go over your trust accounting procedures in your firm. And most people that I deal with, most of my clients, before they've met with me, they have their office manager who handles these things, right? And they've never reviewed, they don't even know that Appendix 1 to the Rules of Professional Conduct exists. I'm going to bet there's a good chunk of you that don't know that Appendix 1 to the Rules of Professional Conduct exists that set out the requirements for trust accounting, okay? Everyone has to review that. They have to know that when this comes in, if they get an $1,800 check, that's supposed to be costs and fees, that has to go into trust. The $300 comes off, that stays in trust, and the $1,500 goes into your operating account, okay? It can't go in to business and then even if it's the best of intentions. I have had clients tell me, well, yeah, I mean, I was going to file the case the next day. Why do I have to put it into my trust and let it clear, and then I got to do this and that? Yeah, well, that's the rule. And if you don't do it, the OLPR will, if given the opportunity, will most likely find it. And they're very good at doing that. I will tell you. Okay. And then the last thing is you have to have conversations. You have to make sure your fee agreements are abundantly clear about what is advanced costs versus advanced fees or flat fees. All right, those things must be treated differently, and it must be clear, not just for this reason, but under Rule 1.5, just generally that's required. So flat fee agreements are the number one thing I'm seeing right now. I am seeing small firms get hit with. So the definition for private discipline is isolated and non-serious. If you've been using a non-compliant fee agreement for 6 years, they may look at that, they may say, I don't know that we can do isolated here, right? And now you're looking at potential for public discipline based on this stuff. So hopefully that scared the heck out of all of you, and you're all going to go back, if you use flat fee agreements, and take some time and review them. If you don't, I'll give you my card later.
All right, so Hansen v. CBS Construction. So this is a case where an employee was hired as a business development consultant, director of business development. The employee then agreed with the president of CBS to create a new entity to use to invest in different construction projects. So the attorney then joined them, the employee, the president, and the attorney talked about creating this other organization. That fell through, and eventually the president and the attorney created an organization. So that caused quite a dispute, and then the employee filed a civil complaint against the organization and the president, and the attorney ended up representing both the president and the organization. So what's important in this case is that the employee, the president, and the attorney had confidential discussions. So this discussion involved information about future operations, corporate opportunities, deal financing, participants, and the attorney drafted the operating agreement. So he was well aware of what was going on. So when the employee motioned to disqualify the attorney based on the conflict of interest, the court held that the lawsuit involved the same transaction. So this deals with Rule 1.9, which provides that the lawyer who has formerly represented a client in a matter shall not thereafter represent another person in the same matter or substantially related which that the person interests are materially adverse. So in this situation, there was a conflict of interest.
So this is one of the ones I use to try and illustrate broader concepts, right? Which is, this is a case that the reason I thought it was interesting, it's actually just sort of a standard disqualification case, is that it illustrates a problem I'm seeing more and more, which relates to Rule 1.9 conflicts, so former client conflicts. I see it a lot in when people leave firms, right? So this one's interesting because you've got someone who is, sort of holding on tight to that role as well, no, I was just the company's lawyer and didn't really realize who they were representing, right? And so that's one of the big takeaways from this is, you need to be abundantly clear about who you're representing and what the circumstances are. And if you think you've learned something that could be then in those prior conversations, right? You have you can't use that information against them in the future. Now, interestingly, you can do that with a potential client, which is kind of weird under Rule 1.18, which deals with your obligations to potential clients, right? There was a recent ABA formal opinion that allows you to, that says that it's permissible to explicitly state and have a written agreement effectively saying, before I represent you, we're gonna meet, you're gonna give me some information, but we agree that this is not confidential, right? And that this would not disqualify me, this meeting would not disqualify me from future representation of somebody else on a similar matter. Okay, so that's permissible. But once you sort of establish that, once there's an attorney-client relationship, which, hopefully we all know is not just contractually based, right? The tort-based standard to establishing an attorney-client relationship is, would a client essentially reasonably believe that you've provided them legal advice? This is the dreaded, cocktail party circumstance where, you're sitting there and they say, yeah, I need a lawyer to do this. You go, oh, I do that. And they tell you the facts and you say, yeah, well, look, here's the deal. Statute of limitations is this, you're fine, don't worry about it. Give me a call, we'll get this taken care of for you. And then you go on about for the rest of the cocktail party and then they think, oh, well, I've got 2 years to get this done. They don't call, their claim's gone, and they claim they thought you were representing them, right? So that's the thing. That circumstance with former clients happens too. And so that's when you get into these circumstances here, where you've got former client issues. But the one that I've seen more and more now is we are in a weird time, in my opinion, in the market. There's a lot of lateral movement, right? There's people leaving firms, there's new firms coming into town, picking up entire sections of law firms and going over. And a lot of people take the position, well, if the lawyer did not work on the client matter at the prior firm, there's no problem, right? So firm A, lawyer was at firm A, moves to firm B, firm A represents a client, right? But that lawyer never worked on it. Then they go to firm B, and the firm says, all right, great, well, actually, we're suing on a similar theory the same, so why don't you just hop on that, right? Well, you can't do that. You can't do that. The fact that, first off, Rule 110 says that there's imputation of conflicts, all right? If one person in your firm has a conflict, we all do, right? So unless you get a waiver, they can't switch sides. They certainly can't switch sides directly, but even on something that's substantially related, so involves similar facts, it's not permissible. And I've had this situation come up multiple times this year, and it really arises most often from these lawyer movement scenarios, right, where they're switching firms, and these circumstances arise. So this is an interesting case. You need to be very aware of who you're representing, and when you're establishing an attorney-client relationship beyond a contractual situation, right? It's not just retainer agreements. So that's the takeaway and the scary thought of this one. I feel like this is like the pre-Halloween attorney scare fest, right? My job is to come here and sort of like tell horror stories around a campfire. But these are times where the lawyer honestly didn't think they did anything wrong, and then they're facing a disqualification motion in district court, and they lose, and now there's a decision with their name in it for the rest of their life about how this back scenario. So you want to avoid that.
All right, so in the case of Nielsen, this involved an immigration attorney who provided, through his paralegal, incorrect information to clients. There were 2 clients in this instance. Yeah. Yeah, is this better? Oh, great, now you guys can hear all my mistakes. No, absolutely. So there were 2 clients in this situation. Both clients were filling out immigration forms, and those immigration forms were provided by the paralegal, and the paralegal communicated that a qualifying relative could either be a spouse or a child under the age of 21. Both clients had daughters under the age of 21 and believed that a qualifying relative could be their daughter, which was incorrect. So this situation led to a couple violations. The first one being 1.4b, which involves communication to the client. The rule provides that an attorney must explain a matter to the client to the extent reasonably necessary to permit the client make an informed decision. So the clients were told that their qualifying relative could be their daughter, who was under the age of 21, which was incorrect. So they went ahead and filled out this form incorrectly. The second one is 5.3b, which provides that a supervising attorney is responsible for the conduct of their non-lawyer staff. Here, the attorney was copied on the email that the paralegal provided. So the communication did go through the paralegal. The attorney saw and admitted to seeing this communication, but didn't make any effort to correct the mistake. So then there is a 0.4c, which addresses the conduct involving dishonesty, deceit, or misrepresentation. So through the paralegal, again, the attorney misrepresented the fact that a qualifying relative can be a child under the age of 21. So there are a couple different violations in that situation.
So this leads to the new one new topic, all right, which I'm going to see if I can get us to this. Rule 5.3 deals with the obligation of supervising non-lawyer assistants, all right? This is a case, this Nielsen decision, is a case in which the attorney relied very heavily on their, this is a fact scenario I'm sure is resonating with many of you, relied very heavily on their paralegal to handle most of the intake and initial discussions in determination of client strategy, like, telling the client what the strategy was regarding a case, all right? And the paralegal was just wrong. It's just wrong. This is just not accurate. It is not a legally accurate statement that she made. And that resulted in, because this was an immigration practice, and for whatever reason, this particular this law firm operated, the paralegals operated with, I would say, less oversight than was permissible, as is indicated by the Supreme Court decision that we're talking about. This continued over and over again, and what ended up happening is the lawyer ended up being disciplined severely for this, because you have to watch what your associates, or well, certainly what your associates are. That's Rule 5.1, right? That's Rule 5.1, so that's associates. And then 5.3 is your assistants and your non-lawyer staff. In the COVID and now permanent, effectively permanent remote hybrid world, all right, most of the law firms I deal with have a dramatically decreased level of understanding of what their staff and associates are doing on a day-to-day basis. All right? They aren't meeting as frequently, they aren't communicating, they aren't doing updates, they aren't having the conversations that we used to have in the hallway, right? Or a break room or whatever it was, right? And as a result, I am nearly certain that these claims are going to increase because people act independently. This is not nefarious. It's not people trying to hurt anyone. They're doing what they think is actually right, but it's not. And because it's not, it's your license that's going to take the hit, right? These issues, I just saw a case litigated, participated in it for a while, that related to oversight of a trust account. There were problems with a trust account that resulted from a failure to oversee, and that went all the way to trial. And the issue that was litigated were the firm's procedures reasonable? Because under Rule 5.1, you have to make reasonable efforts to oversee what's going on for subordinate lawyers. Same thing here under 5.3. So if you are the managing partner of a law firm, that's on you. You could have nothing to do with the case. Not a thing, right? There was a case that got litigated and actually was overturned, not overturned, but the referee decided it was not a violation, about an associate's mistake in failing to file in the 1 year, you hip pocket serve it, and then you have to file it within a year, right? So the associate didn't know that rule and didn't file it. They litigated that. Now, in that particular instance, the referee determined that wasn't a violation for the managing partner, but I'll tell you what, that law firm probably spent six figures in getting that win. So I don't really think you'd call that a win, right? That's a loss based on the fact that the view that the OLPR seems to be taking now, and I think is going to become more and more prevalent in our remote world, right, is that you as the managing partner of a law firm have an obligation to actively monitor compliance with firm procedures, firm policies, to oversee the work of everyone, and if you don't do it and they screw up, that is on you. So I would, if you don't have, I've represented a number of firms. I've said, so what's your policy on remote work, right? How do you oversee remote work? And they said, well, we don't have one. I said, okay. So what happens with something goes sideways? What's your defense going to be, right? What's your defense going to be that they just went completely off the rails on a representation, right? An associate that you hadn't seen in 3 weeks come into the office. You didn't see them for 3 weeks because they weren't working. They were in the middle of a mental health crisis, right? And you didn't know, and all of a sudden things are getting missed. And there was no policy of the firm that someone had to check in, that we had to, review work. Those things will come back and they will hit you because this is the one time where it rolls uphill, right? Normally it rolls downhill. But when you run a law firm or you're a partner in a law firm, it goes, a supervising lawyer, it goes uphill. And so be aware of that, and you should be, especially if you're allowing, as we all, I think, probably are now, people to work remotely, you should have some policies in place, you should have some protections, you should be thinking about when something happens, how am I going to show that I was reasonably supervising these people, right? So,
Can I ask
yeah, please.
somebody who's rolls uphill?
Yeah.
How do we do this? I mean, is there a structure where I say
Yeah, no, I mean, this is a good question, and the question is, how do you do this, right? And you know, thanks to lawyers, everyone in this room, we define everything as reasonable, which means it could be anything. But what I will tell you is the policies that we have in place at my firm, because I mean, as associate general counsel, we were concerned about this during the pandemic, and thankfully we were able to avoid problems. But we have now instituted policies that require shareholders overseeing associate work to check in, you know, periodically, which I think we've defined as some number of weeks or something like that around cases, and then there's also, we have very clear policies about where things have to be saved. One of the things that I have seen in one case is we had an associate who was saving everything offline because they were having trouble using whatever their system is, right, for documents. And so all these documents were offline and available only on his desktop. And so one of the policies that I suggested in that circumstance is you have to have a policy that says every piece of work product must be saved to whatever your firm's document management system is, so that God forbid something happens to that person, the work can be picked up by somebody else and move forward. There isn't a loss of work, all right? And in that case, there was work that was billed. There was a mental health problem for the associate. Associate has to go and get help. There was work that was billed, that was done, but was not available to the firm. So the client paid for something that had already paid for something that that was not in their benefit. That is not a good fact pattern for anybody, right? So again, it's the idea, these are the kinds of policies you have in place. You want to talk to one of the things, I don't know if you have, for those of you that have associates, I personally check in with the associates on my files at least every week. And it's a lot, I know, and it's a lot of time. And it's usually, by the way, not billable for both of you. So someone's got to eat that, right? But that's just the kind of stuff that you have to do if things are happening in your case. This dovetails, it's a slight diversion, but I think we've got plenty of time. A slight diversion, these issues dovetail with the mental health, the lawyer wellness issues that we've been seeing. As you guys all know, and I think we talked about this 2 years ago, the Supreme Court issued 2 or 3 years ago, sort of a call to arms, if you will, about issues of lawyer wellness. I am seeing mental health, substance abuse, stress management, just breakdowns in 40, 50% of my cases now. And it is isolation, it is pressure, it is all of the things that always existed before the pandemic, but now you don't know they're happening because you never see these people. You don't see them when they come into the office and they're just red-eyed and, and lethargic and unable to work. You don't know that because they're working from home 3 days a week, right? So, if we're going to move towards, and I don't think we really have a choice, I think the market has pretty well told us that remote work is going to be here in some form for most of us if you want to recruit. These kinds of policies of being in the office some amount of time, interacting with shareholders, having policies about document management, stressing the importance of oversight to your shareholders and your supervising attorneys are all things that you absolutely have to have. And just write them down. I mean, the fact of the matter is you're going to want to have things written down, right? The idea that we have a de facto process here for these things, with the 5.1, 5.3 issues I'm seeing come up, my advice to every law firm is write them down. Have a policy manual. I know that seems impractical, but I'll tell you what, when I get involved, you're going to want that, right? You're going to want me to have something to defend you. Because otherwise, if the answer is, well, we've just had this practice, and it's me and an associate and 3 paralegals, and we've always just done it this way, and if the OLPR investigator talks to 2 of those people and they don't line up, right, on what the policy or practice has been, well, that's not going to be good for you. So write them down. Talk to people and implement them. So So yeah, that's the Nielsen case. And I'll tell you this case, you know, this is a really pretty standard case. This is not a, oh my God, situation. This stuff happens all the time. And so I apologize to Mr. Nielsen, who's getting stuck being the exemplar for this, but I've seen 4 or 5 of these in the last 12 months. There we go.
All right, so one of the hot topics that we'll be discussing today is in relation to attorney-client privilege. So December of 2021, the Supreme Court of Minnesota adopted the predominant purpose test, which is for assessing whether attorney-client privilege protects a document that contains both legal advice and business advice. So briefly, the background of this case, Polaris recalled a line of ATVs for potential fire hazards. When the U.S. Consumer Product Safety Commission launched an investigation, Polaris retained an attorney. They retained an attorney to conduct an audit of its safety policies and procedures. This attorney and the team created an audit report. That audit report provided recommendations in safety, engineering, design, corporate practices, so touched different areas. The audit report was marked privileged and confidential. Fast forward to a year later, Polaris was sued by a consumer who was severely burned by one of these recalled ATVs. Polaris inadvertently produced a copy of this audit report during discovery. They were unsuccessful in clawing it back. And the question was, is this audit report truly protected by attorney-client privilege? So in determining this, the Supreme Court considered the fact that the audit report was discussing design, engineering, other practices, with the goal of improving the process Polaris uses to assess safety risks. One of the discussions was that there is a difficult line drawn between business advice and legal advice in certain situations, because often attorneys rely on their experience, on their expertise to provide business advice. So it's hard to make that distinction. Ultimately, the Supreme Court said, well, we need to consider quite a few things. So consider the purpose of the report or the document, the content, the context in which it was communicated, the recipients, whether the legal advice permeates the document, or whether any privileged matters can be redacted. So this is a critical point as well, because even though it may have legal advice in it, that doesn't mean that the document in its entirety can be privileged, can be protected. You would then move forward to just redact those legal components of that document. So again, ultimately, the Supreme Court in this particular case held that the primary purpose was business advice and not legal advice, because it took practices and policies and to determine whether they were compliant or not. And they truly did emphasize the redaction component of these situations.
So when this case came out in December, our firm sent an email to everybody and said, read this immediately. And the reason is we're a defense firm, right? We represent a bunch of big companies, insurance companies, we do trade secret litigation, we do non-competes, we do all types of stuff, right? And now, I mean, thankfully our practice has always been to redact as much as possible, because it just reduces discovery fights, right? And we've always, I think, thankfully, applied what is effectively the predominant purpose test. But we very frequently would see in cases, and our firm does some work on the plaintiff side too, just the wholesale withholding of documents that are hybrid business legal, right? And what this case says is you better be pretty careful if you're just gonna mark that whole thing as privileged and not redact it, all right, and produce it as on a redacted basis. And this puts lawyers in I think in a tough position in the sense, one of the reasons why I wanted to talk about it, not just because it's important and you all should know about it, because for those of you on the plaintiff side, this is awfully helpful. For those of you on the defense side, this is a risk management problem for you, right? Again, you're not watching which associate's putting together your privilege log, and all of a sudden you get a sanctions motion because there's a bunch of documents that were withheld entirely because the associate didn't know about this and you hadn't told him about it. That sounds pretty familiar to a fact pattern I just talked about, right? Things that you gotta make sure your associates know, make sure your paralegals know if they're doing them. This case, I think, is one of the bigger decisions that's come out for anyone who does commercial litigation in at least the last 4 or 5 years. It's a huge decision. It fundamentally changes the way that attorney-client privilege procedurally is dealt with in district courts. And so it's a weird case. It has a very odd procedural posture. Olivia did a really good job of summarizing what the predominant purpose test is. Good luck trying to figure that one out, right? It's like, well, okay, well, is it predominant meaning what? Is it 50.1? Do you have to create some sort of a spreadsheet and aggregate the amounts and words and which was what? No, I mean, that's the problem, right? It's gonna be hard, but you're gonna have to make a good faith effort to comply with this if you want to avoid sanctions motions for improper withholding of documents that should have been produced as redacted. And so I think this is a huge case, and I think it's a really important one for everyone to be aware of. Also, one thing that it does brought to mind is the issue of inadvertent production. Who watched any of this sort of the Alex Jones trial stuff, right? Right, and that lawyer effectively produced text messages, privileged text messages during trial, and my recollection is didn't even really attempt to claw them back afterwards. That person is screwed because those were completely used or absolutely unquestionably used to the detriment of the client, right? There's a bunch of ethics violations. It is in my opinion, I'm not gonna, I wasn't involved, and so let me disclaim everything, right? But there's a big asterisk right here when I say this. But to me, it's like, well, let's see, you've got a negligent act that caused damage. Got pretty good shot at taking a run on that one in the district courts. So I think that one of the things that you really have to be aware of when you're doing any case that's got text messages, heavy email use, is inadvertent disclosure. You should be QCing your productions. It costs more. It costs more, but we have a second level review on pretty much every document production that goes out the door if it's in any level complex. If there's anything more than 500 documents, we're doing some sort of second level review to try and make sure, whether it's 10% or whatever, to try and make sure that you're not having these inadvertent disclosures, because this wouldn't have come up if the counsel hadn't turned the document over by accident, right? This whole case doesn't exist. This decision does not happen if there wasn't an inadvertent disclosure by somebody during the underlying litigation. So there's my scary statement for that one. You want to talk about the rule a little bit here?
Sure.
Go for it.
So Rule 1.15, let me just grab my notes here to make sure. So this goes back to one of the cases that we talked about client funds being, client funds within connection with representation must be deposited in identifiable funds or identifiable accounts. So this goes back to whether it's in the business account or a trust account. To be compliant with the rule, the lawyer must withdraw earned fees within a reasonable time. So the key in here is earned fees, right? So if there are advanced fees, you can't withdraw any of that amount until you have earned the fees. Also, provide the client with written notice of the time, amount, and purpose of the withdrawal in accounting with the client's funds in the trust account. So this goes back a little bit to an earlier rule, which is communication. You have to communicate with your client what you are doing. It's not about their case necessarily, but you do have to communicate about their fees and what they have, what you have processed as an expense. So just transparency is important with this one.
And the reason we're talking about 1.15 is, in addition to the fact that it dovetails with what we talked about earlier with the Majors decision, I've had a number of cases recently that involve inadvertent overdrafts of trust accounts. And they almost always are bank errors, right? Just bank screws up, pulls it out of the wrong account. I hope most of you know that when a trust account overdraws, there is a requirement that the bank notify the board, the OLPR, and the OLPR initiates as a matter of rule an investigation, all right? If you don't have fully compliant trust account records, which are substantially more complex than you probably think they need to be, but they subsidiary ledgers, all of these trial balance reports, a written memoranda reflecting electronic transfers from your trust account, right? So you earn fees, you would electronically push them out of that account into your operating account. Appendix 1 requires there to be a written memoranda of some kind. Now that can be an email that says, authorizing lawyer says, please transfer X amount from the trust account in this subsidiary ledger for services performed, approved by the client, right? But if you don't have that, you're not compliant. A lot of my clients, when I tell them, they don't realize that you can't have more than $100 in your trust account of firm funds, that, right? So if you can have $100, up to $100, as essentially a buffer, just in case there's something like, and to cover things like checks, right? Check expenses. If you don't pull your earned fees out within a reasonable period of time, you're going to exceed that, right? And you're now commingling firm funds with client funds. That is a violation. If something happens to some of those funds, that could be negligent misappropriation. Negligent misappropriation, thankfully, is much less than intentional misappropriation, where, you know, Mr. Majors got the lowest I've ever seen. What was that, 3 months? Majors got 3 months, but he had to litigate the thing. So he spent months, I've litigated these cases, months, and if he had counsel, tens of thousands of dollars to get a 3-month suspension, which frankly, when I came out, I was floored. It's the lowest I've ever seen. And one of the reasons, by the way, that he was able to get 3 months is he was retiring. He was retiring. So, you know, unless that's your fact pattern, you're probably not getting 3 months. So the point is, all of these things are to show you these technical components that you're like, oh, well, that's just a technical rule. Unfortunately, there's no such thing as a technical rule. It's a rule that must be complied with. And so if you have fear about your trust accounts, call an ethics lawyer, call an accountant who's got experience dealing with trust accounts. By the way, a lot of CPAs that I've dealt with, because I do a lot of trust account work for the firms that I represent in trust account investigations, a lot of the CPAs don't really fully understand the trust accounting requirements, right? They apply normal accounting principles. That's not their fault. They're just weird. It's a weird subset. So you really want to look at and find somebody who's got an experience dealing with it to ensure that your stuff is compliant. We had a case not long ago where an attorney passed away, solo practitioner, suddenly. Really sad, right? So we get brought in to try and help because they're trying to figure out what the hell to do. And the trust account hadn't been done, really had anything done to it. They hadn't really reconciled it in years, right? So now you're having to go back and recreate that stuff because there's clients that need refunds. There's former clients that need refunds. There's amounts of money that you don't really know where it comes from. It might be firm fees. It might not be firm fees. There might be a client from 4 years ago that's sitting there, doesn't realize that they have $500 coming from, right? So I think you guys can all see why that's a problem. So this is my scary statement about trust accounts. That is, I think that's it for us, but I'm going to talk for 6 more minutes in order to make sure we get, is that about right? 5 more minutes? What do we need?
No, you guys stopped early last year.
Did we?
And gave us a full hour.
Oh, all right.
Can I ask one more question?
Yeah. Yeah, there we go. We'll take that.
More and more, I'm a plaintiff's lawyer.
Yeah.
And more I'm seeing diversity in my clientele.
Mhm.
I mean, people who aren't here are first generation
Yeah, right.
Americans, and they don't speak English.
Yep.
It's impractical to get a translator for every time I
Yep.
Are there ethical problems with doing that?
So that's a good question. And the question is when you've got a client who's maybe first generation doesn't speak English very particularly well, or at least needs assistance in understanding the concepts and the legal advice being provided and giving you the information. Is there a problem with using, say, a teenage, a child or a family member who might be able to assist in translation? So there is some case law that says that as long as the intention is to keep those privileged, right, those communications privileged, and there's a discussion essentially that what the purpose here is that this person is translating and assisting the client in understanding the legal advice and providing information necessary for the provision of legal services, that's still privileged. Same thing with, there are exceptions under Rule 1.6 for disclosure of information, right, confidential information. The important is being intentional about it and talking about it. Never presume that everyone understands how this works. Your first discussion where this happens is there's going to be a discussion with both of them that says, you're here for this purpose. Everything I'm telling you is a privileged communication. It's incredibly important that you and your parent understand that we don't have a conversation about these issues absent, a lawyer. These are supposed to be kept confidential, and you have to kind of have that conversation with everybody. So that there's the intent element of the privilege is maintained. And I do see that a fair amount. It is a really common problem, but the case law is clear that you can use, well, I shouldn't say clear, no, it's never clear, but there is case law that says that you can use third parties who are not like official translators for the purpose of the client understanding legal advice. Yeah. Yes, sir.
I want to go back to imputed disqualification for lateral transfers. As I read the changes that have been made in 1.9, it seems that they added in this qualification that if I go to a new firm, I'm only disqualified if I have actual knowledge of confidential information. There's a comment in paragraph 5 that says the firm isn't disqualified and I'm not disqualified unless I have some information from my client.
Couple of things to know about that. The Minnesota Supreme Court has determined that the comments are not authoritative, so that's one thing. The second thing is you should just screen. I don't think the firm would be knocked out, right? The issue is that there's a screening mechanism, because the fact of the matter is that unless there were restrictions within the firm, there's no real way to know whether confidential information has been disclosed. And so what I would tell everybody, and what I do in my cases, when we have people come in from firms, we automatically screen them. In doing that, it eliminates any threat, right? Any potential question, and it complies with the way that I read 1.9A and 110 as they work together. I agree with you that there was a change. I know, and trust me, I'm aware of that. But that is an issue that is really hard to, who do you ask? What do you say? The associate says, yeah, I never heard anything about that case. I have no clue. I never looked at the file. I mean, it's really hard to confirm that, right? And I think a client has a reasonable basis to say, well, that's concerning to me when they've switched firms. So I think you just put up a wall and no issue at all at that point then, and there's completely risk-free. Any other questions? Otherwise, I think we're dead on. All right.
So with all the things we read in the newspaper about the lawyers board, has that impacted from your perspective how they're doing things?
Yeah, it has. I mean, the turnover has been incredibly high. I mean, it's not uncommon for me to have now gone through 3 or 4 investigators on a file before it's done. I have really good working relationships with the folks at the board, at the OLPR. I've got a good working relationship with the director. I don't really have any opinion as to her efficacy or anything along those lines, but I will tell you that the turnover has been incredibly high, and it has impacted operations. I think resolution of complaints is slowed. I just tried a case where the underlying acts were 4 years ago. So You know, that's tough. I mean, we had a witness die in that period, right? I mean, it's that long. So, so those are. I think it is slowing things. I think it is making it difficult to get. I think it's also making it harder to get consistent resolutions because there's just isn't as the institutional knowledge isn't really there. I think the director's doing the best she can with the facts, with the circumstances, but it's been it's slow. It's really slow. I tell my clients now, you could be doing this in 18 months without any doubt. Like this could be resolved in 3 months. It could be resolved in 2 years, and it could be resolved in 2 years with a complete dismissal, right? With no public anything. So it's not just that it's the bad cases that are taking forever. So, yes, sir.
One of our listeners, viewers in our remote audience, just to prove they were listening, said, please ask Aram to correct something he said. Lawyers are allowed to keep a nominal amount of $200 extra.
Oh, 200, that's right. You're right. Sorry about that. You're right. It's 200. Yeah, I apologize. No, you're right. Thank you. All right, I'm willing to admit when I'm wrong. But yeah, but still, 200 is not very much. Yeah, right. Don't go over that. You know, when you get the I've had $1,500 sitting in my trust account because I just thought, hey, we want to make sure it doesn't overdraft. That's the problem. So.
And I just asked Jim while you were talking. I said, do plaintiff's lawyers actually know all this stuff? And he assured me they do.
Yes.
So it turns out he's right.
Yes.
I assured him that I have people who work for me.
And you're adequately supervising them, of course. Right, exactly. So, all right. Any other questions, or else we can call it and be exactly on time within. All right. Thank you very much, everyone.
Okay, next up is a former sport coat recipient, Shane Hammond, one of our frequent flyers here, always does a great job keeping us up to date on the happenings in the no-fault system. Shane is a partner at Arthur Chapman, who I'm sure you all know. Also, Shane, one of our viewing audience said make sure that they repeat the question before they answer it, which I thought we were doing a pretty good job of, but just as a reminder. Don't forget to put your card in the Viking drawing if you're so inclined, if you're willing to go to a Viking game. Should refrain from commenting, but go Gophers. Here we go.
All right, good morning, everyone. I'm here to deliver kind of a light topic after talking about, you don't have him? Okay, well, I'll just start talking anyway. A little lighter topic, right? We've talked about kind of heavy, dense topics that kind of make us sit at the end of our chair and wonder if we're kind of monitoring all those people in our firm, those who are working on our cases. So hopefully the next 20 minutes or so will be a lighter topic. Brett always tells me, make sure you're kind of neutral. Don't give too much defense side stuff away. Don't give too much claimant side stuff away. So while they're pulling up my slides, I would encourage all of you to take out your smartphone, right? We've all got them here, right? We've probably all checked them. How many of you have gone on the AAA website and looked at, the no-fault portion of the American Arbitration Association? A few people, good. There's some interesting information out there, right? You don't probably want your name on there, but there are a couple people who have kind of violated some of the rules, and the conduct has arisen to being publicly reprimanded. some kind of notes from, I talked to Krista Peach and Kelly Baker, who run the AAA. The AAA was the only arbitration services organization that submitted a bid in the spring of 2020 to re-up for administering these claims. And they've been the only arbitration organization that has administered these claims. And I think, you know, some of that provides continuity, right? We know who these people are. We know what these systems and procedures have in place. So I think that helps all of us do our job. But remember to copy the case administrator on all emails. I know most of us say, gosh, you've probably told us that before, Shane, right? But I can tell you the fair number of cases I have, something happens and someone isn't carbon copying the case manager. The case manager needs to know what's going on. If you're an arbitrator and a hearing is left open for additional records or bills or parties to comment or make an argument on something, let the case manager know, because that differentiates and determines when the award will be due. If you're the arbitrator, make sure that you complete all the hearing record information, including the claim amount. You know, make sure your math is correct. You know, back in the old days, we used to fill out a form and then fax it, email it, mail it to the case manager. They would type it all up, send it back to us, and we would proof it. So gone are those days. So just make sure that your math is correct, and everything should be more streamlined now, especially since COVID and most things are happening via Zoom and electronically. You can fill in these forms, create it into a PDF if you want, email it back to your case manager. Another reason why I asked you to take your phones out, for those of you who are arbitrators in the audience, there is a AAA application. How many of you have it downloaded? Anyone? Jody. So yeah, you can download the Panelist eCenter mobile app. So this will allow you to access your cases. You know, if you're running late for a hearing or you're having Zoom technology issues and you're hosting the hearing, you can reach out to the parties, because that information will all be in your Panelist eCenter, and it's all at the ease of your mobile app. And it's available, obviously, through Google Play and the Apple Store. And I did have a slide of what it looked like, but if you just, it's up now? Okay. So there's what it looks like. So very, very user-friendly, intuitive, allows you to kind of move forward with your cases kind of wherever you are. Another thing that AAA kind of reminds you about is gone are the days of kind of snail mail checks, right? Mail is slower these days. It takes longer to get things. So if you want to be paid quicker and you're an arbitrator, sign up for ACH payments. Then you'll receive that payment quicker. If you need that form, it's on the AAA website. And so very easy to get to. Filing fees, they've gone up. Sometimes I'm not quite sure why things have gone up, when you'll see in a few slides the number of cases filed has significantly gone downward. There's a downward progression since about 2013. But claimants' filing fee is $50, up 10. Respondents' filing fee is up to $200, up from $150. So some additional changes in the fees. I'm going to talk a little bit about motions. How many think the AAA process for motions is a bit cumbersome? Yeah, it's a little bit, back and forth. Not as streamlined probably as the court system, right? You have a meet and confer, you have a phone conference with the judge, you might submit some letter briefs, 1 or 2 pages, quick emails, things of that nature. You try to resolve it. So I would encourage all of you, if you have a discovery dispute, try to work it out amongst yourself, because the problem is this process is so cumbersome. So if Mark Melzon, who's checking out that Panelist eCenter app, and I have a discovery dispute, we have to meet and confer about it. We have to talk about it over the phone. We have to exchange emails. If we can't agree, I advance my motion. I deposit my $150. Then when Mr. Melzon replies, he submits his $150 and his motion. And then the AAA sends everything to the arbitrator. The arbitrator makes a decision and then determines who's going to pay his fee of $100, and the AAA gets $50 for the administrative aspect, and then whoever doesn't have to pay is refunded that money. So there's a lot of back and forth. And I was on the AAA Standing Committee when this was put forth, and, there was a lot of collaborative discussion about it. And I think kind of the intent was, we hope most of these people can, work through their discovery disputes, whether they're pertaining to an examination under oath, an IME, different discovery materials that someone wants, someone else doesn't want to provide. And so we intentionally kind of made it a little bit more difficult. But, just kind of keep that in mind when you have your discovery disputes. If you end up paying, having to pay the $50 administrative fee, and then you want to advance it back as, say, a counterclaim in a portion of your case if you're the respondent attorney, or tack that on to your case if you're a claimant attorney, you can do that under the rules to try to get that cost-saving measure back. And I think that's another avenue for parties to hopefully, come to the table and find a resolution or an agreement, so they're not going to the arbitrator and requesting a motion. The updated arbitration petition form, so this was updated obviously because of COVID, and it was updated because a lot of hearings are not going forward in person, so some of the information does not need to be in the electronic form anymore. But on those electronic forms, obviously, you get to select, do you want it telephonically? Do you want it in a video conference format? Do you want it in person? Do you want it documents only? I do see plaintiffs' attorneys, claimants' attorneys checking off telephonically and video conference, and I think that was done initially because letting the other side know, or letting the AAA know, we're fine with telephone, we're fine with video conference. Now the petition form specifically says, just choose one. If you choose more than one, we're going to default and think your first choice is telephonically. So just make sure that you're adequately filling out the form. And then on the back of the form, because it is a requirement to make sure that the insurance company who you've listed as the respondent has received adequate notice of that petition, that you indicate how you provided that information to that adjuster at an insurance company, whether it was through email, through mail. If you look on the AAA website, they do have a list. Certain insurance companies have designated one individual to receive all of those claims. So I would encourage claimants' attorneys, check the website before you're filling out your petition or having your staff fill out your petition. So more of what I just talked about. The other thing I'm going to talk about too probably dovetails and kind of is in line with the heavy discussion we had on professional responsibility. But the AAA and the No Fault Standing Committee really looks at arbitrator disclosures. And the new arbitrator disclosure form was implemented probably 4 or 5 years ago. And I think that it warrants me reading it again, because I'm going to go over some recent scenarios that I've had that I'm kind of bewildered as to why these arbitrators accepted this case and then kind of wasted the parties' time only to be removed and another arbitrator appointed. But the rule says, no person shall serve as an arbitrator in any arbitration in which he or she has a financial or personal conflict of interest. Under procedures established by the Standing Committee and immediately following appointment to a case, every arbitrator should be required to disclose any circumstances likely to create a presumption or possibility of bias or conflict that may disqualify the person as a potential arbitrator. And this is it's an active, ongoing disclosure. So if you find something out during an arbitration hearing, don't wait. Go ahead and disclose it. Regularly update your arbitration disclosure. It's fairly easy. Send a quick email to the AAA, hey, since I completed my last arbitration disclosure form pertaining to this case, here's some new and updated information. It might be significant to the case, it might be significant to the counsel, it might not. Don't wait is the kind of underlying message. Here's some common scenarios. A couple of these I've seen this week. 2 arbitrators on 2 of my cases were removed. One, the arbitrator was sharing a fee with the claimant's attorney on a file. So I commend the arbitrator for disclosing that. He was sharing a fee. But then he said, I can be fair and impartial. And I said, well, wait a minute. How can you be fair and impartial? You're violating Rule 10. Claimant's attorney says, Well, the rules are in place, and the arbitrator has indicated that he can be fair and impartial. Well, the AAA removed that arbitrator, appointed a different arbitrator to hear that case. So in my mind, I was thinking, why did this arbitrator kind of waste the party's time on this? He should have said, listen, I've developed a conflict. I can no longer hear this file, hear this matter, told the AAA case manager, and the AAA case manager could have appointed the next arbitrator. That didn't happen. Related to one of the attorneys on the case, I had a case recently where I didn't know this, different last names. The arbitrator was the cousin of the claimant's attorney. So he disclosed that, but then said, well, I can be fair and impartial. Yeah, personal conflict, family conflict. Probably should remove yourself, just don't even accept the case. Having represented a medical provider who has medical bills in dispute, and you have germane knowledge about how that company functions, how that company decides how to bill medical providers. You've handled intimate cases for them, not just ABC Chiropractic refers a file to John Doe for an injured individual. That's a different scenario. I've had cases recently where a claimant's attorney who is an arbitrator said, oh, well, I previously represented the claimant in this lawsuit, but I think I can be fair and impartial. And you laugh, it's a lot of this stuff we sit and chuckle, right? But I'm standing up here telling you that, either people have shown me these particular conflicts or I've been a part of them. So I think when you're filling out those disclosure forms, just take the time that you need, disclose the information that you need to, and if there is something like a family connection or you're sharing a fee with someone, just tell the AAA I've got a conflict, I cannot be appointed as the arbitrator in this case. Then they move on to the next arbitrator. You haven't wasted anybody's time. Same thing goes with, we're a small legal community. If you've talked about a case with somebody and you've got intimate knowledge, you shouldn't serve as an arbitrator, because we want arbitrators to be fair and impartial. Same thing goes for arbitrators who have gone through a hearing. Even though you've been appointed and you've heard a case, arbitrator complaints are a little bit on the rise, and sometimes that's because all of us are so familiar with stuff. So you have to make sure that you're procedurally handling the case. If someone wants to give an opening statement, allow them to give an opening statement. If someone wants to, belabor a certain point, ask one more question, let them do that. Because arbitrator complaints are a bit on the rise as far as not allowing parties to complete, whether it's direct examination, cross-examination, things of that nature. So the arbitrator complaint form is a 2-page document. You can find it on the AAA website. Generally, these complaints arise after an arbitration hearing, because of some sort of conduct that happened. What happens when there is a complaint is the AAA and the No-Fault Standing Committee will appoint usually a 3-person panel to investigate those complaints. Someone will talk to the claimant's attorney, someone will talk to the respondent's attorney, someone will interview the arbitrator as well. They compile, all of their information, put it into a memo format, it goes to the committee as a whole, and there is a vote as to whether or not there should be some disciplinary action. Is it private discipline? Is it public discipline? You can look at our website and see, like I talked about earlier, those who've been publicly disciplined for, things that may seem minor to some of you, some that may seem fairly major to some of you. It also goes with, your disclosure forms that you fill out, keep those up to date. But it also goes to, each year you recertify as an arbitrator, right? Make sure that you're filling out the components of your practice. If you practice 100% plaintiff's personal injury, indicate that. If your practice has scaled back to, gosh, I only do 50% now and I do 50% wills and trusts, make sure that you're also indicating that so the parties who are selecting you know what your background is. Because one of the arbitrators who was publicly recommended kind of just haphazardly filled out his certification form, and it wasn't accurate. And he was caught by one of the parties. So if you do this, you allow this process to continue, right? We like this arbitration process. These no-fault arbitration claims run much smoother. We've been able to continue on despite COVID, right? Some jury trials that we have in court cases in different counties are, at a standstill or are now finally moving forward. But no-fault arbitration hearings, we kept on going, right? Maybe there was a week or two lag after COVID, and then we jumped on with Zoom. So it's really allowed the process to move forward. Any comments regarding opinions that you may have about what a particular insurance company does or what a particular medical provider does? Keep those to yourself. I primarily handle defense-related claims, so don't tell me you don't like it when an insurance company retroactively suspends benefits, or that you don't like Dr. Nipper's independent medical examination reports, and when you've read one, you've read them all. To certain individuals, that could potentially be something of a relate to a bias matter, and that's what we want to avoid. Qualifications to be an arbitrator. This has changed a little bit. It used to be 1/3 of your practice had to be within the personal injury arena. Now it's 1/4. Over a 5-year average, 1/4 of your practice has to be in the personal injury arena. Or if you are actively practicing, not actively practicing but have an ADR practice, 1/4 of your ADR practice has to be within the no-fault arena. You have to have practiced at least 5 years in this state. So if you come from a different state and you've practiced there for 20 years and, Wisconsin, and now you're in Minnesota, you have to be actively practicing here for 5 years before you can apply to be an arbitrator. You have to complete the AAA standing committee's approved arbitrator training. You have to have at least 3 CLE hours within your reporting period. So me up here speaking would be about that. You'd get about 20%, you'd be 20% there. And then arbitrators are required to certify each year. We've streamlined that process. So you're certifying prior to the end of this year for next year. They used to kind of do it more on a rolling basis. So now, just make sure you get that certification in prior to 12/31 of 22. Otherwise, you'll have to reapply. Now I'm going to go through some statistical data, so some color-coded slides. So, this illustrates the number of arbitrators on the panel. I don't think it's probably any surprise to either claimants' attorneys or defense attorneys. 74% are claimants' attorneys, 25% are defense attorneys. 1% can claim that they handle equal amounts of claims for both sides, and I think that's probably more in outstate Minnesota. So based upon that, the number of arbitrators, so you've got a little over 300 arbitrators total. Looking at the statistical data, maybe 2-3 years ago, lots of people were applying to be arbitrators. It seems to have gotten, kind of dovetailed downwards from that. So if you want to be an arbitrator, the information is on the website. The AAA and the standing committee would meet in January. So just make sure you'd have your information in. Popular hearing locations continue to be, Twin Cities metro area as far as where arbitrators are pooled from. Eagan, Minnetonka, Roseville, probably no surprise there. Same thing with outstate Minnesota, St. Cloud, Rochester, Mankato, Duluth. The next slide is fairly interesting. You can see in 2013, there were about 7,400 arbitration petitions filed. And you can see it's steadily gone down to, in 2021, there was about 3,500. So we don't really know what that is, if more insurance companies are paying up bills, or attorneys are adequately able to settle those cases prior to going to an arbitration hearing, but you've continued to see the decline, and that has also corresponded to, we don't have quite as many case managers as we once did, but those numbers continue to decline. The next slide shows, just kind of a compilation of how many hearings are going forward. They're kind of, almost 50-50 phone versus video conference. Some are going forward in person. I think since COVID, I've had one in person. The claimant was blind, so we had to go forward in person. So, kind of absent those special circumstances, most of them are going forward kind of in that virtual format. And that has made probably all of our lives easier in that you're not traveling. You can get all the parties on fairly quickly. The next slide shows, it's probably a little bit hard to see, but just kind of medium and maximum awards between wage loss replacement services, medical expense benefits, and it's kind of hovered around that $7,000 average award for kind of medical expense benefits. So there hasn't, despite the number of cases that have gone down, when cases actually go to an arbitration hearing, that's about the median size of the award. And you can see there's obviously numbers that are higher than that, numbers that are lower than that, depending upon how much coverage is available when you filed for arbitration, how much care and treatment occurred after you filed for arbitration. And then the last slide I have talks about, the number of cases that went forward as far as how many were settled versus how many actually went to the arbitration hearing. And you can see that those two numbers, that 45 and 46, they're almost 46, and they're almost exactly the same, 45.8 and 46.51. Half the cases, once they're filed, go to our arbitration hearing, and the other half settle. So that's what I have for statistical data, and I'm around if you have any questions, or I can take any questions now. And my friend Jim Carey always has a good question for me.
Since you were expertly trained at my law firm as a law clerk, I've had many good questions for you. Jane, I have been doing this for 35 years now. I'm an arbitrator often. I'm still on the panel, and I enjoy it. But there are occasions where the issue is pretty straightforward, and it's reasonableness and necessity. And I've had plaintiffs' lawyers, claimants' lawyers, and respondents' lawyers who want to talk and argue for 45 minutes on something that seems very apparent. Am I going to get spanked by these AAA if I tell folks before we begin that they have 20 minutes to give a closing argument? Is that a no-no?
Do you want me to repeat the question?
Sure.
Okay, so Jim had a question for those in the on the live stream about he understands the process of no fault. He's been doing this for 35 years. He understands the standard reasonableness, necessity, causal relation. Is he going to get in trouble by one of the parties if he says limit your question or limit your arguments to 20 minutes? The answer is kind of a slippery slope answer. Yes and no. I would say it's know who the attorneys are on the case. I think if arbitrators come in and say, I have read your statement of the case for both sides, I understand the issues in dispute, I've read the independent medical examination, I've read the narrative report of, Dr. Smith, I understand that, claimant was involved in a motor vehicle accident and she went on to have a low back surgery, and there's a question as to the reasonableness, causation, and necessity for this. I think you've set out at the outset for the parties that you understand what's going on with the case. So in that particular situation, you'd probably be fine saying, limit your closing arguments. I do have attorneys, arbitrators on my cases will say, go ahead with your closing. Here's the 3 things I want you to hit. I want you to talk about, causation, or I want you to talk about, why your IME report is more solid than Dr. Smith's narrative report. So I think if you, streamline it into, here's the areas I want you to focus on, you're fine. If you've likely given them an opportunity to make an opening statement too, that's another opportunity for them to present their side of the case. I think a lot of times it comes with maybe newer attorneys who are less experienced with the process, and maybe they're working under someone who says, okay, you've got to make sure that you say these 5 things. Obviously, if you've got a court reporter there might be some additional concerns there to put more information on the record. But every case is different, so use your best judgment would be my recommendation. Yep. Anyone else? All right, thank you so much.
Okay, so hopefully everybody is, I know they were still here when I put this list together. We had a little drawing out in the hallway. Tattersall Distillery in, used to be northeast Minneapolis. Now it's in River Falls, Wisconsin, because we should have taken this up with our reg folks, but they don't allow Minnesotans to produce enough alcohol, apparently, so they had to move their operation to Wisconsin. But it's a really cool place over in River Falls if you want to go over there. Tattersall, they have a really nice setup, great dining and so forth. Plus, they donated 6 bottles of hard liquor for us to give away. So that's always that's a win-win, right? And we had a drawing out in the hallway, and there's no favoritism here. This is just how it worked out. Danielle Bird. So you want clear liquor or brown liquor? All right, 1 clear for Danielle. And you can go out and get it. It's out in the hallway there. Lindsay Carpenter. Clear liquor, I assume, or brown liquor? Clear it is. Alex Klein. A first-year attendee here and a member of the Cousineau firm that's one of our most solid customers, so we're happy to pull him out. Tim O'Connor, brown liquor, I assume, right? Yes, sir. Out in the hallway. And I don't know about you, Alex, you better get out there. Brian Stoffern, because I know Brian, we already cleared with him, he does drink hard liquor, so he may have already captured one of those brown liquors. And Chris Villione, last but not least, you're the winner of either brown or clear, whichever left as soon as you get out there. So have at it. All right. Congratulations. And on to Jim. There we go. Oh, and let me just one more thing on that, just for our folks. When Marty Cole used to come here to do the ethics, we asked him specifically, is it okay to give away liquor at this thing and still not have to worry about there being some ethical violation or some issue? And his answer was absolutely, as long as you don't open it. So this is all good. Nobody has to wonder, geez, I wonder why they're doing that. Are we in trouble here? So according to Marty Cole, who was the director for a long time, we're all good. All right.
Oh, Brett, you better put that bottle under your table out in the car then. Our next presenter, and as long as we're in the mood to give things away, is also the recipient of the Woman's Blazer that one of our vendors is giving away. And Not Standard has been a presenter here at our event for many years. And Melissa Stahl has been a speaker here for many years from the Sewell and Stahl law firm. And I am happy to have her come and speak to us about products liability issues. So Melissa, you want a jacket?
All right, thanks Jim, and thanks for the jacket. As Jim said, I have presented at this the last few years, and I used to give a hot topics and products liability presentation, and for those of you who practice in the products liability realm, there are not a lot of new cases and new developments in that area. So this year I decided to do a more primer of sorts. I learn a lot at these CLEs about areas of law that I don't practice in, but I often am left thinking, I don't know the first thing about that. I could use a 101. So that is what I decided to frame my presentation on today. I do practice in primarily products liability, law, and commercial litigation. I have a firm here across the river in Minneapolis, and we represent manufacturers of farm equipment, hand tools, construction equipment, vehicles, etc. So what is product liability? Under Minnesota law, strict liability, negligence, and implied warranty have all been lumped together under one products liability theory. In products liability claims, we almost always see these three causes of action: design defect, manufacturing defect, and failure to warn. A design defect claim essentially requires three elements. First, the plaintiff has to show that the product was in a defective condition that was unreasonably dangerous. So, for example, you've got a lawnmower, and there was an accident involving a rollover of the lawnmower. The plaintiff has to establish that the lawnmower was defective in a way that made that mower unreasonably dangerous. The second element is that the defect existed when it left the defendant's control. So sometimes in a lawnmower case, you'll get a claim that it was defective because it didn't have a rollover protection system. Well, if the manufacturer designed the product with a ROPS and at some point someone cut off the ROPS, that becomes a harder claim to make, because that product was not in the same condition as it was when it left the manufacturer's control. They might say that you should have made it so you couldn't cut it off, for example, but that is an element. And then the final element, as it is across the board, that the defective condition caused the injuries. So in every state, there's a little different standard for what you have to show to prove a defect. In Minnesota, it's the reasonable care balancing test. So in Minnesota, you have to show that the product's design is defective and unreasonably dangerous by balancing the likelihood and gravity of the harm with the precaution that would have been effective to avoid the harm. In Minnesota, oftentimes what is looked at for that precaution is an alternative design. So the precaution has to be possible and feasible by the manufacturer, and generally requires an expert to talk about what the alternative design is. An alternative design is not actually an element of defective design, and I think this is an area that is often litigated. But there are a lot of cases in Minnesota where the courts have decided that if a plaintiff is arguing that a product should have been modified as opposed to just completely taken off the market, if you're arguing it could have been made safer by putting a ROPS on it, it could have been made safer by changing the inherent design of the product, then you need an expert to proffer an alternative design, because that design is the, quote, precaution that could have been taken to avoid the harm. And there's a Minnesota District Court case that says without an expert explaining what that alternative design is and how that design could have prevented the harm, the jury can't possibly engage in that balancing test as is required under Minnesota law. Manufacturing defect has essentially the same three elements, but here we're looking not at whether the design is defective. In other words, every lawnmower that doesn't have a ROPS is alleged to be defective by design. Here we're looking at an actual manufacturing defect, an error that occurred on the factory line. I have a case now where a forklift is alleged to have a manufacturing defect because a component in the brake pedal assembly was allegedly manufactured defectively. So it could be a one-off, just only this one forklift is allegedly defective. But it's the same three elements. The product was in a defective condition and unreasonably dangerous. That manufacturing defect existed at the time it left the manufacturer or the defendant's control, and that defect, that manufactured component caused the injuries. The third claim is that we almost always see as failure to warn. A plaintiff has to show that there was a duty to warn. In other words, the defendant knew that there was a possibility, they knew that an injury was foreseeable, and needed to warn against it. Here, for example, if we have a stump cutter and there is a rotating cutter wheel on the front end of the stump cutter, there is going to be an argument that there is a duty to warn that that stump cutter can cause a hazard. The second element is that the defendant breached the duty by providing an inadequate warning or no warning at all. Typically, a warning needs to identify the hazard, talk about how to avoid the hazard, and what might happen if you encounter the hazard. So for a stump cutter cutter wheel can cause serious injury or death. Stay away. The third element is, again, causation. The defendant's inadequate or non-existent warning actually caused the harm. Here, you look at, did the plaintiff read the warnings and instructions? It's hard to establish a failure to warn claim if the plaintiff testifies in deposition. I didn't read the manual. I didn't read the on-product warnings. I didn't attend the training. I never do that. I never read manuals. Well, then no matter what the defendant might have warned against, you can argue would have had no impact because he never would have seen a better warning. You can also establish that the plaintiff knew of the hazard, independent of what the defendant warned. Back to the stump cutter example, you can establish in a deposition that the plaintiff knew that a rotating cutter wheel can cause serious injury or death, and he did not need to read that in a manual. He did not have to have anyone tell him that. So essentially, would this failure to warn often comes down to, would it have changed the outcome? No, failure to warn also has, in addition to what was in the manual, what did you tell the user at the outset, a post-sale duty to warn component. And up until 2018, the post-sale duty to warn was mostly reserved for, quote, special cases. There was a Goodyear tire case in 1988 that recognized that a manufacturer can have a post-sale duty to warn. In other words, the product is out there. It's in use in the field. The manufacturer, the defendant, learns of an issue and then has to go out, find the consumers, find the users, find the owners, and issue a warning after the fact. So in the Goodyear case, it was found that can be the case in certain situations. In 2018, the Minnesota Supreme Court defined this a little bit better. And in that case, there was a fire in a home in Eden Prairie, and the allegation was that the fire stemmed from a component of the HVAC system that had been installed in that home 16 years before the fire. The allegation was that the manufacturer of that component knew that there were issues and should have gone back and issued warnings for all of those components that were out in the field. So the Supreme Court in Great Northern adopted the Restatement Third of Torts, Products Liability Section 10, which essentially says that a reasonable person in the seller or manufacturer distributor's position would provide a warning after the time of sale if the seller reasonably knew the product could propose substantial risk of harm, and that those to whom a warning would benefit can be identified, which is an interesting issue when it's a component. It's a lot easier if you've got a registered stump cutter or vehicle where you are the manufacturer and you know where those products are. If it's a component integrated into another product, that creates a whole different set of issues. But the user also has to be unaware, assumed to be unaware of the risk of the harm. You also have to show that the warning can be effectively communicated and acted upon, and that the risk of harm is sufficiently great to justify the burden. Oftentimes, post-sale warnings come in the form of some sort of service bulletin, notification, generally not a full-on recall, but that type of process. And that can be burdensome depending on how many products are out there. So there is a weighing factor that the risk of harm is sufficiently great to justify that. And all these 4 factors are conjunctive, so the plaintiff has to prove all 4 to establish post-sale duty to warn. Causation, as I've said throughout these 3 main causes of action, causation has to be established that the defective condition or the lack of warning actually caused the injury, and that oftentimes requires expert testimony. If the causation is beyond a layperson's knowledge, then the plaintiff typically does have to introduce expert testimony to causation. Another essential element throughout products claims are foreseeability. So in design cases, manufacturer's duty to make a reasonably safe product arises when the injury sustained was foreseeable. There's no requirement that manufacturers make fail-safe products that can never cause an injury, but it has to be reasonably safe. And the duty arises when that injury is foreseeable. And typically, duty is an issue for the court and can be decided at the summary judgment phase. But there was a case in 2017 that makes that summary judgment likelihood a little less now. That case was Montemeyer versus Seabright Products. And it involved a high-density extruder machine, and it processed discarded food containers. It essentially crushed the containers with a hydraulic ram. The injury resulted when the plaintiff climbed into the extruder to that discharge chute to clear a clog. And there was a warning on the product that said, danger, do not enter. Unfortunately, the coworker did not know that he was in this chute. The coworker discarded a safety device that was on the product. No one had locked out or tagged out the machine when he climbed in. And again, not knowing, obviously the plaintiff was inside, he started up the high-density extruder machine, and the plaintiff sustained significant injuries. There, the district court granted summary judgment, saying that it was reasonably foreseeable that a person might get into the machine in disregard of the warning, or that somebody might have activated and run the machine without implementing the safety device. But it wasn't foreseeable to the manufacturer that both of those things would have happened. The Minnesota Supreme Court disagreed and found that this was a sufficiently close case that it could not be decided on summary judgment and should be left to a jury, that it was a factual dispute regarding the defendant's awareness of whether this was foreseeable. So that case is significant in that it changes a little bit the landscape of summary judgment on product liability cases. Next aspect that is in almost every products case is expert witness testimony. I have never had a products case that didn't involve multiple experts. We're dealing with design engineers, different types of mechanical engineers or electrical engineers that talk about how the product was designed, what is happening in the industry, how it compares to other products. Usually there's a warnings and a human factors expert talking about whether the warnings were reasonable, what they should have said, how a person interacts with these warnings, and a biomechanic. Back to the lawnmower example, if you have a rollover incident that results in a death and there are no witnesses, biomechanics can come in and figure out how the product rolled, how the injuries were sustained, what actually caused the death. Similar with accident reconstruction, get folks in to examine the scene, examine the product, examine the injuries, and try to piece together how something happened. The courts in Minnesota have decided that certain products, most products do require expert testimony. They've found that when a product and its, quote, inner workings are beyond the ken of a lay jury, we need to have an expert witness. Some examples where courts have found that expert witnesses were required are cases involving pacemakers, and how the pacemakers work, as well as the reasons why they fail to perform, required expert testimony. The design of an electrical and a mechanical system of an elevator required expert testimony. And the expert must be able to testify why the defects constituted an unreasonably dangerous condition. And an expert's testimony, everybody probably recognizes this movie, every lawyer's favorite reference to expert witness testimony, My Cousin Vinny. Under Rule 702, both in the Minnesota State Rule and the federal rule, require that if technical or specialized knowledge will assist the trier of fact to understand evidence, facts at issue, and the witness is qualified to testify. Everybody probably remembers from that scene, Marissa Tomei is testifying as an expert witness, and they wanted to challenge her qualifications, and she rattled off all of the reasons. Her dad was a mechanic, her uncle was a mechanic, her grandpa was a mechanic, and she knew everything about it. So just because she appeared to maybe come off the street in movie world, she was qualified. In Minnesota courts, it's a little harder to qualify an expert sometimes. The standard in state court is FRIMAC, and in federal court, of course, it's the Daubert standard. And essentially, the testimony has to be reliable and it has to be relevant. It's going to be reliable if the expert can establish those qualifications, that he or she has the technical, educational experience background to help a jury understand what's going to be presented, and that the methodology is reliable. In other words, what the expert either did him or herself, or what the expert relied on is reliable. And it will be relevant if they properly apply their opinions to the facts, and that's going to help the jury decide the case. Recent case in expert witness admissibility is this Kurjowski case. The Minnesota Supreme Court ruled in 2019 on this case. Here, the district court granted judgment as a matter of law after a $27.7 million verdict came in. The district court excluded the entire opinion of the plaintiff's sole causation expert. The Court of Appeals affirmed that ruling, and it went up to the Supreme Court in 2019. And the Minnesota Supreme Court found that the exclusion of the expert wholesale was improper, and it was an abuse of the discretion when they found that just one aspect of the opinion lacked that foundational reliability. So the Supreme Court determined the expert opinions were grounded on more than just one basis, and the other grounds were okay for the court to admit. That case actually was remanded, and the subsequent jury trial verdict found that plaintiff's fault was 100%, or plaintiff's contributory negligence was 100% of the cause of the injuries, and the defendants were not liable at all. But this kind of piecemeal exclusion of experts' opinion, I think, is becoming more common. That's what happened with my last expert challenge. This summer, received an order that the expert's opinion as they pertain to design defect and failure to warn were unreliable and excluded, but opinions on manufacturing defect could move forward. The 3M bear hugger litigation, a lot of you have probably heard of this case. Some of you probably are pretty intimately familiar with it. But last summer, August of 2021, right before this event, I talked about this a little bit last year too, the 8th Circuit Court of Appeals reversed summary judgment in favor of 3M, which revived plaintiffs' negligence and strict liability claims in a multi-district litigation involving nearly 6,000 lawsuits. So after the first bellwether trial of those cases, which resulted in a jury verdict for 3M, the MDL court excluded plaintiffs' engineering and general causation medical experts and granted summary judgment to 3M, dismissing all 6,000 of those MDL claims. But on appeal, the Eighth Circuit applied the standard for reliability of the Daubert test and concluded that the MDL court excluded those experts in error, finding that the underlying opinions were in fact reliable, and whether or not those opinions and that methodology was created just for litigation goes to the weight of the evidence, not to the admissibility. So that opinion was just denied recently certiorari by the United States Supreme Court, and as of earlier this week, that case is set to go to trial this month. So I am sneaking in under time. That's my Products Liability 101. If anybody has any questions, let me know. Otherwise, thank you.
I have a question.
Yeah.
How's a manufacturer, what's their duty to anticipate a potential injury from a particular product? How do they know whether a warning is really required?
Goes to, oh, yes. So Brett's question is, how does the manufacturer know if a warning is required? How do you anticipate what you need to warn against? Goes directly to foreseeability. Oftentimes what we as, I am a defense lawyer, what our clients typically talk about is the nature of the hazard. Again, a stump cutter, I think most people are going to say you need to warn that the cutter wheel can cause serious injury or death. There are certain situations, though, where accidents happen that you thought you either designed out or you just never even foresaw. A strange workplace situation that imposed a hazard on a product. A product is used in a way that you never anticipated it would be used. Misuse and product alteration are defenses to that. But it goes down to foreseeability. If you have a bunch of reports of accidents because of one particular fact pattern or one aspect of a product, it's probably going to be found foreseeable that you need to warn against that.
And is that a legal issue for a court, or is that a fact question?
Foreseeability is usually going to be a fact question, especially under that new, the more recent case in Minnesota, the name of which I'm completely blanking on. What? Thank you. Yes, Montemayor. Yes, found that it's going to be really hard to determine foreseeability at summary judgment now. Yeah.
The court decides that it is a close question of foreseeability for the jury. Does that become a standalone question on the special verdict form, or is it wrapped up into an element of negligence and reasonable care?
Well, in a products liability case, it wouldn't necessarily be a negligence standard. It's a strict liability standard. So it would, the question is whether or not foreseeability is a separate line item on the special verdict form. And I would have to double check the standard form. I don't think it is. I think it's just those three elements that are going to be on there, and you have to argue it in closing argument that it should fall under one of those.
Anything else?
Okay, thanks.
All right, yep, next up is Andy Rorvig. Andy's been with us for many years, always does a great job. Former sport coat recipient. Last year, actually, we gave him the Golden Gopher sport coat, which he promptly wore down in Iowa City. We were proud to see that. So anyway, was not necessarily a good outing, but maybe this year at the home, right?
Yeah, why not us? Why not now?
Right, exactly.
Yes, we do. And who hates Iowa? Just checking. Just checking. I mean when I say, well, good morning, everyone. I'm going to take this thing off, otherwise I can't see my notes. It's fun to be here. This caps off an exciting week for me. I got to go try a case for the first time since March of 2020 when, where's Tupa? Tupa and I tried one the first week of March of 2020. And then from then until now, that there's been nothing else. So I told the jury I was excited to be there. And most importantly, I was excited that I was wearing pants for the first time in a court proceeding in 2.5 years. I guess that's the Stearns County and me. So let's talk about health insurance real quick and subrogation interests. My wife told me not to say that joke, but I couldn't help myself. So nobody tell her, please. Click, click. Here we go. So we're going to hit on 5 things. Hopefully. That's 3. Sounds like 4. Here we go. 5 things. We're going to talk about ERISA health insurance plans. And so the first couple topics aren't as germane for my defense friends, but I promise you there's going to be an application for you as we get to the 5th one, which is where Brett wants me to name some names. And so listen up as we get to number 5. But first one is, do we as plaintiffs' lawyers, have leverages with ERISA plans when we're trying to settle our cases for our clients? Do we have a leverage to reduce what we pay back a health insurance plan to maximize our client's recovery? If you're taking notes, the answer is no. There is no leverage, and I'll tell you why. Mainly because the U.S. Supreme Court in the last 15 years has shut the door on every opportunity to reduce the powers and the rights of an ERISA plan. Second thing is, what if you don't behave as a plaintiff's lawyer? What happens if you violate this rule that you have no leverage and you try to be funny with the money? What happens to you? We'll talk about the ERISA plan's rights. Is there any benefit to taking an assignment of a health insurance plan? We'll quickly go through that, and the answer to that's going to be probably not either. And then we'll talk lastly about future medical. What happens when you settle the case and your client continues to treat and they've got an ERISA health plan? Are you going to have issues with getting coverage and coverage for those bills paid going forward? The answer is most likely, depending on what type of a plan you have. And then lastly, we'll name some names about what's the impact to the defense when there's a health insurance plan that's an ERISA plan involved. All right, so we're going to go quick. First one, and this goes to this issue about, do you have any leverage with the health insurance plan? And so the Supreme Court now has had 3 or 4 cases, and they all say the same thing, which is the health insurance contract governed by ERISA always governs. So whatever's in the contract is what you're stuck with. And of course, people like United Health and others have broadened the terms of that contract. And so now those contracts, those terms basically say, if you, the plaintiff, get any money, regardless of causation, regardless of fault, regardless of an itemization on a jury verdict form, it doesn't matter. We get paid first. And the courts have continually upheld that. So this is a case from a couple years ago. It was a very novel approach. It was a situation where someone down in Rochester couldn't get a deal cut with the Health and Welfare Fund, which, by the way, is the worst to deal with in terms of these plans. They couldn't get a deal cut. They sent the check to the health insurer along with an attorney's lien, which they tried to enforce. So in other words, they owed $200,000. They sent it with a 1/3 attorney's lien to try to recoup back from the plan a 1/3 fee. You want to guess if it worked? No, not so much, right? Again, the plans have the right. The court favored the plan. They cannot reduce for attorney's fees. There is no lien mechanism to allow reduction. So crash and burned on that, but novel approach. Second idea, what if your settlement doesn't include medical? And this is kind of interesting. It's a little technical, but it was a wrongful death claim. It was in the 8th Circuit. And as we know, when we're making a wrongful death claim, generally the biggest part of the claim is the pecuniary loss. And so with regard to this, the plaintiff's lawyers said, listen, we're not making a wrongful death claim for any of the medical expenses. We're just solely making a claim for the pecuniary losses. And again, a wrongful death claim is based on statutory rights. It's not a common law claim. And so they painted by number, they thought, and said, listen, we've got a really novel argument. We're not making a medical claim. It's a pecuniary loss claim. The court has to approve the distribution. That's all it is. we don't owe you anything ERISA plan. Sounds good, right? Couple problems. One, the release included mentions of medical expenses. So when the case got resolved, the smart defense lawyer puts the broad language in there. It says you release all claims, pecuniary losses, medical wage, yada, yada, yada. So the court says that's a problem, right? I know you're telling me there's no claim for medical, but that's not what the release says. And the plaintiff's counsel agreed and said, yeah, that's what it says, but there's been no consideration for it. There's a number of cases out there as well that say the same thing, which is you can't go ahead and put together and itemize your own type of settlement. We don't care. The contract says we get paid first dollar every dollar. So regardless of how you structured the settlement, at least in your mind, or even if a court verdict, a jury verdict would come forward saying these are the amounts, we don't care. The ERISA contract always governs. We get paid first dollar every dollar. So again, a novel approach, but that doesn't work either. ERISA contract wins.
They told, and so what they did after we engaged them